with karakia today, and we are sensitive to that. I understand it was a unanimous view of the iwi and supported by other parties as well. So we are sensitive to that, and if at some stage you want to change who gives karakia, that we're more than happy with that. So I'm going to now start with counsel for the applicant, or the appellant in this case, Perjuli.
Yes. May it please the court, Gibbons for the appellant, Perjuli Development Limited.
Thank you. And is it just T, or is there another initial?
T in Gibbons.
Thank you. And have you got another counsel beside you, or is that a instructing party?
No, I've got the two witnesses with me is instructing.
That's fine. Thank you. Turning to the council, just trying to ascertain who's who in the pictures, but I take it, we've got Ms. Ridling, is it, for the council?
Good morning. May it please the court, Ms. Ridling, Ridling, K, Kirsty, appearing for the council. Behind me I have my two witnesses.
Thank you.
Thank
Excellent. You. And for Tūranga Waiwai, Board of Trustees.
Te kai whakawā tēnā koe, ngā kumihana tēnā kōrua, otiria tēnā koutou katoa. Ko Kitu Maua ko Mataira ngā māngai mō Tūranga Waiwai Board of Trustees. Sir Kitu and Ms. Mataira are appearing today for the Tūranga Waiwai Board.
So your initials, Mr. Kitu, were?
KK. My first name's Kuru.
Thank you. And assisting you is?
That's Carmen Mataira, Carmen with a C.
Mataira, M-A-T?
A-I-R-A.
Thank you. And for Tūmai Nupu, Ms. Thomas?
Is tēnā koe, sir, o tira tēnā kōrua, e noho ana I tō tātou taumata. Ka mutu atu I tāmaki ki te mara o hine amaru, hei taku matua, he mihi ana ki a koe, nau I timata I tātou hui I te atane. Sir, Ms. Thomas, representing Ngāti Tamainu Po, AT. I also have my junior Ms. Herewini online, AH. Tēnā koutou.
Thank you very much. And AH, thank you very much. Is there any objection to me referring to the relevant parties as Tūranga Waiwai and Taimai Nupo? Is that acceptable?
That's fine for us, sir.
I'm not making any conclusion as to their status. All I'm trying to have is a convenient way of referring to the parties. Sorry, we've lost somebody there.
I had no problems with that either, sir, just to be with my friend.
Thank you. Now, Madam Commissioner, are you happy if we remove our masks? I think we're sufficiently distant from everyone, and I'm happy for Ms. Thomas to do that as well. Now, all I could say is, given the rate at which the numbers are increasing, my suggestion is that you wear it whenever you're not at your position in court. Of course, I make no directions as to the other parties. It's up to them. They have their own arrangements in place. I need to now discuss housekeeping, but before I ask parties for their housekeeping matters, I just need to go through the current state of play for the court as we understand it. There was a supplementary statement filed for Ms. Cowan, which according to me was tab 3, her original. This seems to be a supplementary, which I will just add at the back of 3, but it's up to parties where they want to put it. I didn't understand there to be an issue. Is there any issue about that? If anyone has an issue, could they just advise me now? It seems to essentially be factual, just containing the changes that are made. The relevance of that, of course, is a matter that I can't comment on at this stage. We'll have to wait till we've seen the position, although, as I understand it, it does identify a number of factors relating to the site in a somewhat different way to the existing change. The second issue is I have received at this stage the submissions for Mr Gibbons, so that we have a copy to follow as he gives his submissions, and I would just ask that the other parties let us have those before they're due to open so that we can see them. I think Ms Thomas may have given them to the court already, but we'll wait till we get to that point before we look at them. I just want to, the major problem we are all agreed with that we have at the moment is nobody has deigned to give us a copy of anything that is useful from the point of view of us understanding the location of all the items. I've in fact got desperate enough to go onto Google Earth to find out what is the layout of the area. Can I say what we would like is a contour map showing us the original power site. Now, as I understand, that was attached to the back of the evidence for Taumanupo, and it's tab 61. That appears to be the most accurate map we have of that. As I understand it, the hillock, if I can call it that, or the higher power site, that's the northern end of that power, is what you can see on the far side of the road on State Highway 1, past the train line. It's a knoll, and it appears the railway line goes relatively close to the eastern extent of that. So if people have 61 in front of them, there's a number of pits, etc. shown there. We don't know what they are, but I suspect they are on the higher land. And that appears to have been levelled for the train line, and the state highway seems to go just to the east of the power site as shown in that map. Then it falls down to a slightly lower terrace, as far as I could see, perhaps 1 metre or 2 metres below State Highway 1 in this site. But this site is actually at the southern end and to the east. So do parties follow what I'm saying? That's why we need a map to show us if I'm right. The cemetery seems to have been constructed over land just to the east of the power site, which is shown with the little lines on it. And I'm not sure what the lines mean, but that's the cemetery seems to be at the southern part of that, and then it crosses the road, of course, and goes down to the terrace, intermediate terrace, and then a further terrace next to the river. It would be really useful if we had something in A3 that actually showed us this, so we could have a sensible conversation about what we're dealing with. And if it could show the original contours. I mean, we have the Perjuli diagrams, but they're cut and fill diagrams and give us very little information that's useful for the court in deciding this matter. Probably fine for Phil, but not much help to us here. Now, I can't find one, neither can either of the commissioners. Are those maps already with us and we just haven't seen them?
No, I don't believe they are, Your Honour, but I could, if I could point you to page 538.
Which tab is that?
Which would be under tab 16, so it's quite a way through tab 16. There is a 538.
Oh yes, the last one, yes.
That map may provide you with, it doesn't have contours per se, but it may provide you with an overall, probably a better overall idea of the site in relation to the PAR site.
Yeah, well, unfortunately, I don't know whether it does or not. I mean, it may be that the PAR site is S14/2. I'm not sure.
My understanding is that the PAR site is, yes, S14/2.
Yes. So that's what I was talking about, and you can see in the photograph where the words Great South Road are, just to the west of that is a whole lot of little white bumps. That's the cemetery as I took it.
Correct.
The area behind it where S14371 is, appears to be the area which is marked on the archaeological maps as part of the PAR site to the south, and you can see some indentations and other things there. I don't know what they are, and I don't know what S14371 is at the moment, but nevertheless, that all is to the west of the main trunk line. So as I understand it, you've got the main trunk line, the cemetery, and then Great South Road.
Correct.
And it looks as though, as somebody, I think, says in their evidence, that the main trunk line was pushed through the edge of the PAR, and you can see the steepness on the at the northern edge where the hillock is, and it looks like it went through the land and other features to the immediate east of the PAR site.
Correct.
But it would be very useful to have a contour map, because that will assist us with the key inquiry as to what the Burrow pits were and where the Coomera pits were, and those issues which seem to be at the heart of this argument.
I can make some inquiries as to whether we can obtain one of those.
Yes, your GSI, do you have GIS or not?
We do, but I'm not sure whether we have that. Like I say, I can make some inquiries and let you know through the course of probably today.
Thank you, because I understood that Waikato had GIS and it had LIDAR as well, which gives you relatively accurate information on contours.
We do have GIS.
Yeah, and that should have a contour button on it. I'd be surprised if it didn't. Most of them do. Okay, well anyway, it would be very useful, I think, for everyone, so we can have a sensible examination of witnesses and we can understand what people are talking about and where they're talking about. If we could have essentially that map that you show there at 538, larger and with contours on it.
I will do my best, sir.
Thank you. Does anyone else have any comment about that or concerns about that?
Nice.
So in addition to that, we have pre-read the evidence, as I think the parties would expect, and we discussed. We also had a telephone conference in which we agreed the order of parties, which I understand to be Perjuli first, then the council, then Te Rangawaiwai, then Tau Manupo, and on that basis, I'd understood that the parties were intending to open first, then call their witnesses in order. After checking with me, I advised the registrar that the translator wasn't required to be here until Wednesday, and he'll be here from Wednesday, so that's both for Te Rangawaiwai and the Te Manupo witnesses. I don't know, but he can attend remotely, or may be attending remotely anyway. I'm not sure if he is. Yes. So he's not attending remotely at the moment. No, he may or may not be, but I didn't require him to be, given that the witnesses that we're dealing with over these days did not require any translation services. So the practical position, as I understand it, is that we now will start with the Perjuli submissions, which I must say were far longer than even I had imagined. 50 odd pages, so I'm hoping that's not going to be the pattern. I don't know if parties realise that if you don't get dealt with this week, then I can't say when an alternative date is available. And I did warn the parties of this before. I don't know why parties would choose to spend most of the day in opening. The issues, to me, are relatively clear. And I won't go into it now, beyond the question that I've just asked about the factual information being important. So are there any other housekeeping? Is there any other matter you had? No, I don't. Commissioner Prime, did you have any other issue you needed to raise at this point? Accordingly, I'll invite the parties if they have any other points they want to raise in the meantime.
Your Honour, if I could just clarify that witnesses are not excluded from this hearing.
No, not unless somebody makes an application. It is normal in the Environment Court that all witnesses hear the other witnesses unless there's an issue of credibility. I hadn't appreciated there was any such issue in this case.
No, there wasn't. I was just clarifying. Thank you.
It's quite normal for the parties to attend, and of course, in addition, I don't know how many people we have at the moment, but other people can attend remotely and watch anyway. Isn't that right?
Yes, that is correct.
On YouTube, and how many are there any other people on at the moment? Or? Yeah, so we have people watching. So unless somebody seeks an order excluding a particular person, then there is no 20 now. Yes, so there is no issue. It's a public hearing, and I don't exclude any of the witnesses unless a party seeks it.
Thank you.
Any other issues, Mr. Ketu? Did you have any issue? No. Mr. Gibbons, did you have any issues?
No, sir.
Thank you. And Ms. Thomas, you?
Nothing from me, sir. Just to say that I hadn't filed my opening submissions yet. They were just
No, that's fine. So it wouldn't be normal just so we have them, so we can have them before us when you give your opening. It's for the others more than yourself. On that basis, I'm going to invite Mr. Gibbons to commence with his opening. Given the length of them, I'd suggest that you may want to consider which parts of it you need to cover in detail and which parts can be skipped over. But it's up to you. I'll probably suggest a few places, like the factual opening, for example. We've read all the evidence, we understand the issues. But I invite you to open for Perjuli.
Thank you, sir. So, presenting these opening submissions, happy to skip over certain points as we go and to take questions as we go through as needed. Have set out, obviously, the site we're dealing with and conscious of the request for a clearer map around that. There is a site map at the very end of the submissions at Schedule 3, and set out the framework of what we are dealing with, which is an appeal against the cancellation of a land use consent. And as you've alluded to, some of the background to that is set out in the evidence already.
I think probably we don't need to do A or B unless there's something in that you think we need to pick up on. It's covered by the various evidence, and probably come to the first legal submission, which is at C, paragraph 10 on.
Yes, happy to move forward to that.
Can I just check before we move on? Are you content that the general description I gave, from what I'd gathered from both having a look and from the maps, was that this site is a couple of river terraces, then you have the state highway slightly higher than the site, fairly flat, and then rises again where the old PAR site was?
Yes, there's essentially two plains with a ridge in the middle, I suppose, is one of the best ways to describe the site. It contours down fairly directly, and yes, is adjacent to road and railway, effectively.
It seemed to be slightly lower than the road, is that fair?
It tapers down towards, a pathway adjacent to the river and then the river itself.
Yeah. No, thank you. So we'll just move to the tests, because it's a good place to remind ourselves of why we're here.
Thank you, sir. So we're dealing with sections 128 to 132 of the RMA, and I've set out at paragraph 10.
Yes, you don't need to read out the sections to us. I've got them up here just to check, but I think I don't recall. Although there's a lot of your evidence is complaining about the review, you'll quite clearly state here, as I see over the page, that you may not agree that the review took place, but you can't attack the legality in this court, can you?
No, we're not challenging that the review took place, challenging the decision made at the review.
That's right. It seems to me that clearly must be the case, given that you'd need to go to the High Court if there was an argument about whether or not the review was valid.
Correct.
So the question is, the review could take place. The question then is, it seems two parts, two questions. Just check if we're agreed and we can move on through that. The first question is, having reviewed it, were the grounds to reach the conclusions that there was inaccuracies and there were significant effects. I think your evidence attacks both of those suppositions. And if there was sufficient grounds, the second issue is what should be done. Essentially, your argument is the appropriate question is to review the conditions of consent, not cancel the consent as a whole. Do I understand that to be essentially your argument?
The thrust of the submission is the most appropriate course of action here is to review the conditions rather than cancel the consent.
And can I say, and I'm putting this to you so everyone else has a chance to think about it and comment, and you may want to come back to me. Having read Commissioner Savage's decision, he quite clearly is concerned, as the court is quite frequently, when parties divide an activity into a number of consents and then seek one part of the consent separately from the others. It appears to have been his intention in cancelling the consent that the application for earthworks and the application for subdivision would be heard together. In other words, it was anticipating a process in which all these matters could be addressed in a more fulsome way. Do you accept that, or is that going to be one of the issues we'll need to decide?
One of the issues this court will need to decide, sir, it's in the evidence and in these submissions that there are quite legitimate and good reasons to divide the consent into earthworks first and then subdivision later. And that's covered later in my submissions. But the essence of it is...
I just wondered, because you'll be aware that there's a great deal of evidence by the other parties about the fides of the whole process and why it was chosen to file just prior to the lockdown, etc. I'm not making any of this up. I'm just pointing out that gets us into quite a contentious area between the parties.
Yes, it does, and the submission of the appellant is that there's not a lot of meat in those concerns. There was a timing of a process to work through, but I noticed that some of them addressed good faith at certain points, and it's the case that the appellant has stopped all works when concerns have been raised, so nothing untoward there.
Thank you. Now, I don't know where you want to pick up in your submissions, but I think probably 14 onwards, I think, is actually, covers the key points in for your case, unless there's somewhere earlier you think you need to cover.
No, I think 14 is a good place to pick things up. That's outlining that we have an initial assessment by council that triggers a review, and then we get to the actual review as a separate step and go through and outline some of the legal aspects of that test.
Yes.
And part of the submission is the Commissioner, on behalf of the Consent Authority, to probably consider that test.
Right. So I think you need to read out now from 15 onwards, because you've just told us what you're going to tell us in 14. So would you like to read that in full so that we've got it in the record?
From 15 onwards, sir?
I think so. It seems to be covering key points.
Thank you. There are a number of cases which describe the nature of a review of consent conditions under these provisions of the RMA, though there appears to be no decision of any court which approves the cancellation of a consent. We have the Barrett case in which the High Court made open a comment that Section 1281C was intended to confer a power to review the conditions of a resource consent, but was not intended to open the door to cancellation of the consent. The power of review under these provisions, including the power to cancel, has been referred to in other cases, with the High Court in Genesis Power and Manawatu Wanganui Regional Council describing the process as providing for wholesale review, subject to the restrictions on the power to cancel a consent. The leading authority in relation to a review under Section 1281C is New Zealand Wind Farms Limited and Palmerston North City Council. In that case, the appellant was granted consent for a wind farm of up to 97 turbines. After construction was 2/3 complete, it was found the application for resource consent had significantly under-predicted actual noise generation. And the consent authority took the view the application had under-predicted noise and noise impacts and sought declarations in this court. Court considered the application of 1281C in some depth, including the test for determining whether any inaccuracies in application materially influenced the decision on consent. And under that review, it was held that there were inaccuracies that had materially affected the decision to grant consent. The court considered the effects of the consent were such that it was necessary to apply more appropriate conditions. And on appeal, the High Court upheld the Environment Court's approach to Section 128, noting the scope of 128 in addressing errors in consent applications and the role of a review as a correction mechanism. What we can take from that case is that in a situation where consent conditions were reviewed under 1281C, and where material inaccuracies were found to have influenced the consent authority per the statutory test, the consent conditions were changed on review rather than the consent being cancelled. And as I said, to the best of Council's knowledge, no court has cancelled a consent under Section 132 following a Section 128 review. So what I do in paragraph 18 is pick up some aspects of that review under that legal test. Section 131 of the RMA provides that when reviewing conditions of a resource consent, the consent authorities have regard to the matters in Section 104 and to whether the activity allowed by the consent will continue to be viable after the change, and that's an important point here. Section 1321 provides the conditions of a resource consent may only be changed if one or more of the circumstances in Section 128 applies. And then at 18C, I've set out the wording of Section 1323. And as has already been alluded to, there are three limbs of analysis there set out at briefly paragraph 19. So it's accepted that there was a review of consent conditions, obviously, but it's submitted that the application for consent did not contain inaccuracies, and to the extent the application may have contained inaccuracies, these did not materially influence the decision to grant consent. And it's also necessary to touch on the point there are no significant effects on the environment arising from the exercise of the consent. Moving on to paragraphs 20 and 21, we note this need for inaccuracies, and the concerns about those are set out in Council's notice of intention to review those conditions and in the evidence of Mr Hill and Ms Cohen. And Council's notice refers to the application not identifying affected persons, not disclosing consultation, failing to identify a pre-application meeting, and not addressing cultural effects. Mr Hill in his evidence expands on these matters. He refers to the application for consent, again refers to the pre-application meeting, and concerns about not providing evidence of consultation with tamanupo. His evidence is also that no information was provided on possible adverse cultural effects on Ngāti Tamanupo, and that there was a failure to identify all mana whenua. Mr Hill outlines that he did not believe the application met the requirements of Schedule 4, Clause 6. And Ms Cohen essentially repeats those concerns in the notice, commenting that the application did not identify affected persons, did not disclose consultation, did not refer to the pre-app meeting, and did not address cultural effects on all relevant mana whenua groups. So we come to this threshold of inaccuracies, and the submission here is they can perhaps better be seen as incomplete information, and Mr Lester and Mr Glover, their statements of evidence respond to these concerns. One of these is that the pre-application meeting is focused on potential subdivision, not land use consent. And these were council's minutes from the meeting, and if they'd been intended to address land use activities, this could have been very clearly noted in the minutes. Perjuli identified Tūranga Waiwai rather than Tamanupo as mana whenua. This was in accordance with communications from Tūranga Waiwai that River Terraces was well within their area of responsibility. And there's a comment on Mr Hill wanting Perjuli rather than council to identify mana whenua. The assessment of environmental effects included with the application noted consultation with iwi generally, in more than one place, and with Tūranga Waiwai specifically. And again, it was open to council if it had questions about the nature or scope of that consultation to seek further information under section 92.
So I acknowledge that you're repeating evidence that your witnesses have given, and that's not usual in legal submissions, but I'm not going to stop you. What I don't understand from this is I understand from Taumanupo's evidence that they sent a letter, an email to Perjuli, I think either the 18th or the 26th of March. Does your client deny getting that letter?
No, receipt of the letter is not denied.
Because that's not clear in your evidence. Your witnesses don't even mention it. That being the case, it was clear that they objected. Was that communicated to the council?
No, that wasn't.
So where does that get you to? Are you still saying you had no duty to advise the council that they had objected to it and had a cultural concern about the site?
There was a cultural concern identified, however, the status of Tamanupo is contested in the evidence.
Okay, so obviously it's going to be the subject of cross-examine, I suspect, as to why your witnesses didn't even mention they'd received that letter, given that it clearly was received during this period. Is it your client's position that they have no obligation to communicate that to the consent authority?
Not in that level of detail, no. So they've outlined their iwi consultation.
Well, okay. Well, I don't want to get into the merits of the report that was provided. Are you saying that the report covered cultural matters that was provided in support of the application?
Yes.
Okay. This is the report from, it is attached to one of the briefs. Just want to check we're talking about the right document. Hold a second.
So there is a
So I'm just looking at the council's consideration of the application. That's tab 14. Are you saying that that considered cultural effects?
So some of the points around council's consideration are set out further in these submissions. A recount of the evidence around that.
So I just want to record this because it's going to be quite an important point, I think. You're saying that Perjuli had no obligation to report to the council the contents of the letter from Taumanupo.
Yes, and to the extent it did have that kind of obligation, it was not a factor that influenced council. Two limbs to that submission, sir.
So have you got any case law to support that argument, which one has to say is novel?
There is discussion in the submissions around the extent to which council was materially influenced, but that's largely a factual test, as I would see it.
I'm just wondering, have you got any case law to support the proposition that it's not on the obligation of an applicant to advise of any objections or information it has received upon consultation with parties? You're saying you have no obligation to tell the council. The council has the obligation to investigate somehow.
Council has the obligation to understand its own responsibilities in relation to the application as well as the applicant's responsibilities.
Well, did the applicant have a responsibility to advise what consultation had taken place and what the results of that consultation were?
Yes, in relation to affected parties.
Yes, well, one of them was Taumanupo, and it got a response from Taumanupo which objected. Did it have a responsibility to pass that on to the council?
The concern that comes through in the evidence is the incomplete nature of that consultation, in the sense it was uncertain who exactly was communicating on behalf of whom and where that had got to because of a shifting position.
I just wanted to raise it because the fact that you haven't addressed it with any case law, I suspect I'm going to get a great deal of case law from the other parties, particularly Ms Thomas, who I suspect will be citing a number of authorities on the proposition. You haven't got any authorities to support your proposition?
Not at this stage, no.
Okay. Well, it might be a matter you'll need to consider and reply because I could be wrong, but given the number of cases I've done in this area, I think there's quite a lot of law on the point. So we'll just carry on then. We're up to D as I understood it.
Yeah.
Sorry, the registrar just told me there's some other information I haven't received. So they have to be printed in some way, do they? Well, that's fine, but he's not referring to any at the moment. Are you? You're not referring to any particular authorities at the moment?
No, sir.
Because that's one of the key issues in this case, is whether or not the objection to Taumanupo should have been communicated to the council and whether the failure to do that was a material inaccuracy.
Yes.
So I don't think I'm telling anyone anything new, but I just think there's some law around the point is all I'm saying. Carry on, you're at D, I think.
Thank you. D touches on engagement with different parties and the uncertain status of Taumanupo from the appellant's point of view. Two Tangata Trust, Maumitu Kita Whenua Marae, and representatives of Ngāti Taumanupo, and noting the distinction wasn't always clear and that no conclusion to that engagement was reached. And given the clear status of Tūranga Waiwai and the uncertain status and mandated nature of Taumanupo, including the fact that Council itself didn't seem to have consulted with Taumanupo on the rezoning of the site, it wasn't clear to Perjuli that Taumanupo would properly have been understood as an affected party, and there is evidence discussing the status of Taumanupo before this court.
Yes, the point I'm just having to repeatedly make is, given that they sent an email objecting to the course of action, are you saying that you had the power to unilaterally ignore that on the basis that they had no status?
Yes, essentially, it's a matter of being an affected party, and the assertion of being that is not necessarily what makes it so.
Okay.
It's part of the appellant. So then we move on at 24 to the extent there were inaccuracies. The test requires these must have materially influenced Council in its decision to grant consent. And it is accepted Council is entitled to rely on the information put forward by Perjuli, but there's not evidence that suggests this materially influenced Council's decision to grant consent. And at paragraph 26, talk about the 42A report on the application, which makes no substantive comment on the potential for cultural effects, talks about archaeological effects and notes the presence of the borrow pits. Council is aware of these. However, the Section 42A report includes only requirements for a Heritage New Zealand authority, which was obtained, and compliance with the cultural impact assessment. And it appears the consent authority did not deem it necessary to specifically address cultural effects. On that basis, it cannot be said that any deficiencies or insufficient information in the application relating to cultural effects materially influenced the consent authority. Rather, it appears the consent authority did not consider cultural effects significant enough to warrant their own analysis, and cultural effects consideration was subsumed on the Council's part within the analysis on archaeological.
Well, to that extent, it does seem to me that that turns upon the extent to which your client addressed cultural effects as opposed to archaeological effects. You've said that the report did so. I've said that I wasn't able to find it. I'm not necessarily saying it's not there. Certainly the council decision, as you've correctly pointed out, did not address cultural effects. You're saying they had an obligation to do it even if it wasn't covered by your client?
It was, what I'm saying, sir, is it was covered by my client in the application.
Okay, can you take me to the document and tell me which page?
Yes, I will go back to the tab for the application. And that's tab A5. Sorry, tab.
I don't quite know what that means, so I'll have to see if we can find it. Looks like it's tab 11.
Yes, tab 11, sorry, sir.
Sorry, just...
Paragraph 2.4 is one of them referring specifically to iwi considerations and the...
sorry, what page?
Page 133 of the bundle, that's paragraph 2.4 there. And there is also a discussion of consultation at page 148, paragraph 7.1. So there's mention of those elements of iwi considerations.
So the first one says, as part of archaeological and then iwi considerations, that they consulted with Tauranga Waiwai Board of Trustees in regard to the proposed site and development works, and they said standard conditions. 7.0 is Section 95 considerations consultation has been undertaken to advise the organisation how the works will mitigate issues of cultural heritage.
We also can note page 145, part of the assessment of effects. Right at the bottom addresses possible effects cultural.
This is the requirement for cessation and recording, etc., in the event that any koiwi, etc., are found.
Correct.
Is this typical in this council? Because I've got to say it's the first time I've seen such issues dealt in this way, given the requirements of the Act. Does it deal with the Waikato, it's got a special name, Act, which gives primacy to the waters of the Waikato and anything that feeds into them, etc.? Does this report deal with that?
I'd have to double check around those aspects, sir, but it's certainly given attention to the higher order planning instruments. That's covered both in the evidence of Mr. Lester.
Well, it deals with statutory documents, environmental standards, regional policy statement, regional plan doesn't deal with the Act at all, which takes primacy over all regional plans, national policy statements and the like. I've gone through this in some detail in previous cases in the Waikato. It's not that this area is without case law, not only in our court, but also in the superior courts. No? Oh well. On the face of it, it appears that the report doesn't meet the requirements of the Act.
I'm not sure I'm in agreement with that, given it was processed.
So you're saying what the processing of the application perfects the decision. Any failure in the Act is, under the Act or the superior documents is to be ignored once a consent is granted.
No, not necessarily, but in this case the application was prepared in a particular way in light of the nature of the effects on the site and was treated as such by council as consent authority.
Well, that's the reason they reviewed it, I suppose, when it was brought to their attention. But the question is, if you're saying that the failure to note the borrow pits on the site, the fact that it was proximate to a pa and had cultural connections, is not something you were required to do, then there's case law on those points, is all I'm pointing out.
Yes, that's acknowledged.
So we're up to 2.27 as I understand it now?
So we were noting at 27 years the consideration of cultural effects and by the consent authority, and the fact the 42A report refers to Tūranga Waewae Board of Trustees as tangata whenua, refers to the letter from Tūranga Waewae Board relating to stormwater impacts and the assessment being signed off by council, by one of the people giving evidence on behalf of council, and indicating that provides information as to the consent authority's recognition of status of Tūranga Waewae. We turn then to paragraph 28. The section 104 assessment indicates that the consent authority considered relevant objectives and policies of the ODP, considered the Waikato Tainui environmental plan, including the presence of the borrow pits, was considered in the assessment, and considered the proposal consistent with Part 2 of the RMA and other planning documents. It's apparent from the evidence, to briefly run through, council knew about the potential interest of Tamanupo through that pre-application meeting. Council was already aware. Council advised another party, which it's presumed has some association with Tamanupo, Mai Nuku Kiti Whenua. So that's council's evidence around that. And to the extent it did not advise the trust, it seems that council may have shared some of Perjuli's confusion about different entities. Noting, of course, that council could have done one or more things with the application, declined to accept it as incomplete, seek further information, or to notify, as was done with the review hearing. Council had rezoned the land as new residential after a public consultation process and had the opportunity there for full consideration of iwi interests, and it's presumed that council undertook that fulsome consideration. It's therefore difficult at paragraph 31 to see how the claimed inaccuracies, deficiencies or incomplete information did materially influence council. Return to the legal test at paragraph 32. 1281C, cast in similar terms to 1323B, requires the review to put itself into the mind of the initial decision maker to determine whether those inaccuracies materially influence the decision. It's not clear that the Commissioner in the decision gave substantive attention to that legal test. and no part of the decision to cancel the consent indicates any consideration of material influence. We then move on from the questions of inaccuracies and material influence to significant adverse effects. These can be considered at various points. In terms of potential effects, at paragraph 26, we traverse some of the evidence around that. I'm not sure, Sarah, if you want me to go through that in a reasonable level of detail or simply skim over it, given some of it outlines evidence.
This is the 36 you're talking about?
36, yes, sir.
No, we've read the evidence. I don't know that there's much to be gained from that. It's up to you if you want to pick out anything in particular.
Yes, just picking up on very briefly, largely a consensus on many of the effects, except perhaps cultural effects. Some of the evidence doesn't quite pick up on the positive effects, which have been noted at various points, including the 42A report for the review hearing. Evidence from Mr. Lester, of course, on various effects arising, including through the protection of a defined borrow pit in perpetuity, which is going to be much more accessible to members of the public than the current private land situation, appropriate signage, recognising historic aspects and cultural aspects of the site, enhanced amenity and access to areas near the river, development of the site, being integrated with other stages of development, the need for housing in the area, and giving effect to the zoning and framework of Plan Change 17. And just very briefly at E, referring to the evidence of Tūranga Waiwai around those positive effects, including the protection of a borrow pit in perpetuity and other positive effects as well. It's noted at 37 that the significant cultural effects claimed by Ngāti Tamanuko, which seem to have been accepted by the consent authority, are quite heavily contested in places. And given the mitigation measures and positive effects in place, it's submitted the third limb of 1323 has not been met. Then move on at 39 to the issue of cancellation versus change conditions. And the thrust of the submission here is that prior authorities support a change of conditions in preference to cancellation of the consent. And at paragraph 40, I outline that legal test in more detail, including the initial assessment under 128, the issue of a notice of review, procedural matter, regard to section 104, the need for regard to whether the activity will continue to be viable, consideration of more appropriate conditions, consideration of inaccuracies, and at G, whether these materially influence the decision, a determination of significant adverse effects, and consideration of a change of conditions versus cancellation. And that feeds into paragraph 41.
Sorry, just before you go to 41, I've had a look at those sections, and it does seem to me that the wording of 132 subsection 3 has the word may cancel a consent. So even if the court concludes that all of the subsection 3 matters are met, it does seem to me that the court then has a jurisdiction to cancel, but it could also revise conditions accordingly. So on the face of it, and that's why I'm saying it now, so all counsel can address that as an issue if they don't agree. Even if the court concludes that all subsections of 3 are met, it still has a discretion as to whether it should revise conditions or cancel the consent. It does not appear that it must cancel the consent if those 3 matters are, and thus I don't see any connect between 131 and 132. I take it from what you've just said you would agree with that analysis, Mr. Gibbons?
Yes, sir. Agree, and make the comment that part of the submissions is that we prefer change of conditions to cancellation.
Well, I agree. The point I'm making, though, is even if all of the grounds under... Because there's a lot of argument about whether all three grounds are made out. Even if all three grounds are made out, it appears that the court has a discretion. Now, of course, the greater the adverse effects, the more likely it is that it would cancel consent, and thus your argument about the effect of the significance of the effect is still relevant to that question, whether it be just a question of merit or a question of jurisdiction. It's the point I'm making. And that fits in well with other provisions in the Act which do give power to take major action in certain circumstances, but obviously you still have the discretion to take other steps which might be more constraining in terms of conditions. And you did say in your opening that the conditions might be different to the ones you're suggesting. So I think at least you've advised your client that the court might reach a different conclusion, even if it decides it shouldn't cancel a consent, as to what the revised conditions might be. Am I correct?
Yes, sir.
Yeah. So that the court has a general discretion which can only cancel if the grounds of 1, 3, 2, 3 are made out. But even if they are made out, it still has that general discretion, and it might be reflected in revised conditions rather than a cancellation. And if we're agreed on that, we might avoid a lot of going around in circles as though there's some sort of absolutism about 1, 3, 2, 3. Do you follow my point?
I do follow your point.
So rather than an absolute statement, once you've made out the grounds of 1, 3, 2, that's the end of the argument. That seems to simply give us full discretion from cancellation to doing nothing to the conditions at all. Now, on the facts so far, I mean, not even your client is suggesting we shouldn't revise the conditions. So the question is there some form of revision of conditions that would be appropriate? And I think it might be put this way, and I just want to see if you agree with me before I ask the other parties, that you might say, in fact, cancellation is seen as a last resort. In other words, it's a scale of response from doing nothing to revising conditions, and there's a wide range of revisions that could occur, to cancellation being the ultimate remedy, if I can put it that way, in the most serious cases. Would you agree with that gradation or not?
Yes, I do. I concur with that.
So I'm framing that so the other parties can answer that, because I think it starts to focus the argument a lot more about what we can do rather than about whether the grounds are met. And I know that you don't accept that the grounds are made under 1, 3, 2, 3, but you'll be aware other parties argue they are made out. So the question is still, even if all those grounds are made out, what should we do? Comes down to a question in the end of the appropriate response.
Yes,
so
that's it.
Probably pick up at 41.
Thank you, sir.
Carry on.
Given the nature of that test, and as you've outlined it just now, sir, it's perhaps unsurprising there appears no case law providing for the cancellation of the consent. It's submitted, it's also apparent the consent authority did not apply all these elements, taking on board your comments as well, sir. The decision to cancel consent alludes to some of these points briefly, but does not contain the degree of analysis of these points that it submitted would have been necessary. Further aspects of the test are considered below, and wanted to touch again on that issue of viability that I briefly mentioned before. Proper consideration of the point about whether the activity will continue to be viable is not apparent from the decision. The evidence before the court is that cancellation will mean the activity will not be viable, and further inability to develop it will mean it cannot be put to the purpose for which it is zoned. And the 42A report for the review hearing also commented on that point as well, with the protection of one borrow pit. That 42A report at the review hearing also expressed concerns about sterilising the site, which would be an efficient use of the resource. So 43 just says
sorry, just before we move on, I did make the point at the beginning, and I think I need to reiterate it, that as I understood the Commissioner's decision, it was that all these matters would be considered in a more holistic way when the subdivision consent was also applied for. It doesn't appear to be his intention that no consent could be applied for, and can I make it very clear that there is no law I'm aware of that would prevent your client from applying for a new consent?
No, there isn't, sir.
And so the suggestion that it means he can never use the site couldn't follow, because he could apply for another consent. And I think, and I know you don't agree, but I think that's why Commissioner Savage's decision appears to say that you have, when you have the information as to the subdivision plan, you can actually make a better decision as to how you might address the various cultural issues. Now, you don't agree with that, and I accept it's not as clear in the decision as it should be, if that was his intent, but I don't say that, I can't see how it follows that it sterilises the site. It simply means you have to make another application.
So the concern is that any subdivision, whether done contemporaneously or separately, depends on some degree of earthworks. So effectively, this decision of Commissioner Savage has, he's left it open to apply for subdivision consent later or together. The effect is that the site cannot be developed because these earthworks necessarily need to precede subdivision.
Well, I just don't see how that follows, because the argument is that full information wasn't there. If you filed another application with full information, then the decision would be made, and if you don't like it, you appeal. And I cannot see how it sterilises the site, because there is no principle of law that I'm aware of that means that you can't reapply for the same site. The inaccuracies were with the application. If the application properly addressed the problems, is the concern, I'm wondering if the elephant in the room isn't that the new proposed plan has more restrictions on the site and may prevent the development of it in part or in full. Is that the real reason that you don't want to go through the process?
No, that's not the concern. The PDP was at a very early stage when this was commenced, and it's only really been fleshed out in very recent times. So that's not the concern. The concern is that the decision of the Commissioner, I suppose, left things hanging for an applicant who believed that applying for earthworks first was quite a reasonable way to proceed with things.
Well, the court has on a number of occasions, no doubt somebody will shove them in my face because they're decisions, some of them of my division and other divisions, and on appeal, indicating that there's a preference to deal with all consents at the same time relating to the activity, and that the partial application can lead to the sort of disconnection that's occurred here. And thus the solution is to apply for all the consents at once. Are you familiar with those cases?
I'm familiar with some of those cases, and certainly provisions in the RMA around that as well. The thrust of this court can be that it's best to apply for things together, but not always essential. And it is important to note we're in a fairly dynamic space around how subdivision can be affected, and it may be these earthworks can be approved and subdivision can then take a different form to what would have been acceptable or allowed under the OTP at the time the application was originally made. The concern is also that the decision of Commissioner Savage says we need to have a more fulsome consideration of effects, but still cancels the consent based on perceived significant adverse effects. So it would have been certainly open to consider some of those effects further, but he didn't consider them all at the time.
Okay, so then you make a submission at 43?
Yes, shows that the test for cancellation in the preceding section of the submissions is more complex than the decision of the consensual authority allows for, and the decision to not properly apply these steps. And as the consent authority has not properly applied the requirements, section 1323B, there is no sound basis for cancelling the consent. So then I was intending to move on to the operative district plan and plan change 17. Again, some of that is covered in evidence. But the point there largely is the focus on the ODP plan change 17, which relatively recently came off effect.
So clearly PC 17 considered the Waikato River and Waikato Raupatu claims, the River Settlement Act. And of course, I was looking immediately for where that was addressed in this application. It must be relevant, wouldn't it, given that the land is immediately adjacent to the Waikato River?
Yes, quite adjacent, but that comes back to the nature of the effects and the cultural impact assessment from Tūranga Waiwai, which was with the application expressed a concern primarily around stormwater.
I don't know where you want to pick up again. Perhaps at 47, I'm not sure, because that's about section 32. Do you want to pick up there? Oh no, it's a bit hard to know. Where would you like to pick up again?
Just briefly note that 45 touches on those high-level planning documents, and 46 just briefly note that the section 32 report for PC 17 included consideration of part 2 and included consideration of consultation under the Treaty of Waitangi and section 8 obligation. Moving to 47, we note that PC 17 saw it as important to have sufficient supply of suitably zoned land to cater for growth in Ngaruawahia, and records that this land is effectively in close proximity to other areas of residential development. Recognising also that some cultural benefits could arise from development because of the broad support for growth areas. Paragraph 48 simply cites some objectives that were considered in paragraph 32, in the section 32 report, and there's some discussion of the ODP framework at paragraph 49 that I won't go through in detail, other than to note at 50 that the Consent Authority's own assessment considered the application on the original conditions consistent with objectives and policies and with Waikato Tainui Environmental Plan, even before we consider the revised conditions which are attached to these submissions as well. There is some comment at 51 and 52 on the PDP, and at the time we were at the review hearing over a year ago now, the PDP was at an earlier stage. Since the appeal has been filed, obviously we've now got to a point of having the PDP notified, and there is some relevant materials in there touching on the site, including a Māori site of significance overlay and comments on the gardens associated with the site. Noted that is subject to appeals, and there's evidence before this court around the site of significance status being contested. And it seems that in doing the PDP, the council possibly didn't have the benefit of the fuller evidence before this court, and there is therefore comment on weight. Moving quickly through paragraph 53, a significant degree of common ground as to relevant objectives and policies. They're outlined in Schedule 2, and comment from the evidence, these sites are not wāhi tapu, The 42A report for the review hearing commented on the appropriateness of cancellation versus other options. Quoting from that, when I talk of sterilisations, there's also evidence that pits are not in good condition and not rua, and are not the only borrow pits in the vicinity of the site, highlighting points of contestation there. Very briefly to outline at paragraph 55, evidence of Mr. Lester around the suitability of the site for development in light of the planning documents, and at 56, comment on the positive effects which Mr. Lester has set out, and some of which are echoed in the evidence of Tūranga Waiwai. Paragraph 57 touches on the evidence of Mr. Hill, and paragraph 58 moves on to some concerns with the evidence of Ms. Cohen, including her consideration of higher order planning documents, particularly PC 17, noting her agreement, 58, with most of the conclusions in the original Section 42A report, noting some errors in the archaeological features on the site, talking about the timing at which Tamanupo claimed mana whenua status, and concerns about her adopting much of the evidence of Tamanupo in relation to PDP submissions, expressing concern that Ms. Cohen notes it's not her place to determine mana whenua, but then asserts this and accepts the evidence of Tamanupo around the site being a taonga, expressing concern about whether this might allow a right of veto, expressing concern about her interpretation of the Waikato Tainui environmental plan, but not taking into account evidence of Tūranga Waiwai to the contrary. Also expressing concerns at paragraph 59 with the views of Ms. Cohen on part 2 of the RMA, talk about that test and how PC 17 took account of part 2 of the RMA and relevant higher order planning instruments. And noting that part 2 has already been properly considered in PC 17. Expressing concern that Ms. Cohen's discussion of Section 8 of the RMA and the Treaty of Waitangi makes no mention of Tūranga Waiwai in that discussion and simply adopts Tamanupo's perspective, even though this is contested on the evidence before the court. Discussion of Kaitiakitanga, paragraph 60, also ignores Tūranga Waiwai. Moving at paragraph 61 to Ms. Cohen's consideration of effects, without noting that it doesn't consider positive effects sufficiently, or the degree to which some of the cultural effects evidence of Tamanupo is contested by Tūranga Waiwai. She also largely ignores the comments made by the Section 42A report writer for the review hearing, where he had an opportunity to consider submissions and noted the positive effects and expressed a view that the development on revised conditions would not generate significant adverse cultural effects. So the conclusion on the planning framework at paragraph 62 is...
Just before we move to that, can I just discuss this unfortunate turn in the evidence to having a go, if I can call it, at the veracity or analysis of another witness, which is not encouraged by this court, and there are several cases involving tramways where the court censured a planner for doing so. I don't know that you go quite that far in this case, but it is unfortunate and not encouraged by the court to attack the analyst, not the analysis. And unfortunately, you've repeated that in your submissions for reasons that aren't clear to me. are you trying to say that Ms. Cohen is incompetent or something? Why have you spent as much time talking about her inaccurate analysis as you have, rather than the facts of the case?
Expressing concern at points of the analysis is simply the reason for that, sir.
So are you suggesting, for example, I would have thought the same could be said of Mr. Lester, that he's hired by your client to give evidence on your client's behalf and therefore arguably couldn't be seen as independent? We routinely accept that as long as the witnesses comply with the standards. Are you suggesting in some way she's not independent?
No, not at all, sir.
Well, then why would you take such an approach to her as saying that her analysis is so seriously flawed if you accept her independence? You may not agree with it, but that's a different issue to having what on the face of it appears to be a go at her competence.
No, simply designed to focus on the analysis that is there, and to the extent that analysis addresses a point like Section 8 of the RMA, the concern is simply to note that there is a different interpretation available to how that section unfolds. That is simply the concern, Your Honour.
All I can say is that there can not be a complaint later if your witnesses are taken on that basis. This is the difficulty that arises once you take the gloves off, that things can get unpleasant, and in my view the code of compliance for witnesses requires them to stick with their argument, not with criticising other witnesses. But you've done it in your submission, and given you haven't resolved from it, that's the way it will go. I do not know what other counsel are going to do, but I've got to say I've been in enough cases to now have a fair guess. And I leave it at that, given it appears nobody wishes to change or retract those statements. So we move on to 62. What's your conclusion? I just stopped you before you came to your conclusion.
Yes, thank you, sir. Submitting that the planning framework supports the grant of consent on appropriate conditions as PC 17 properly and comprehensively considered higher order planning instruments, Part 2 of the RMA and iwi issues. Evidence identifies consistency with PC 17. Other evidence ignores PC 17 and the background to that to some extent. And the grant of consent subject to revised conditions is consistent with objectives and policies of the ODP, including PC 17. Cancellation of the consent, on the other hand, is inconsistent with the zoning of the property and applicable planning frameworks. Paragraph 63 addressed briefly the appropriateness of separate earthworks consent, but given we've already discuss that topic.
I think it might be important to go through it because it is a matter of conflicting evidence, and I think myself that you should go through it. So I would go through 63 to 66.
Yes, sir. Thank you. So the decision of the consent authority to cancel the consent placed particular weight on the fact that the consent under review was for land use only rather than subdivision. The reasons for a land use consent for earthworks being sought separately from subdivision consent canvassed in the evidence of Mr. Lester and Mr. Glover. Perjuli is currently seeking...
I'm interested in that because I went back to that reference before, and I think it was one sentence in Mr. Lester's. I don't know what Mr. Glover said. We better have a look at those paragraphs. I just want to check what you're actually saying. So, tab 1. Paragraph 56. Pragmatic construction considerations as they applied to the site. Compaction and soil properties experienced in previous stages meant that an efficient use of time would be brought into the development. I've got to say I'm completely nonplussed as to what that even means, never mind what explanation it may certainly have been a pragmatic from the client's point of view, but that doesn't help anything. That doesn't explain anything beyond the fact that they were able to and got a subdivision earthworks consent before the subdivision consent. Where was the next explanation? That was 56, 62.
Just address that briefly, sir, around those pragmatic considerations. Some of them obviously can be fleshed out in discussions, questions for these witnesses. But some of that relates to the timing of earthworks, given the nature of an earthworks season.
Well, perhaps, but the problem I've had is I was told by the witness, I've already told you what this was, he says. I go back to it and find nothing I can understand there. There may be a further explanation, but it certainly wasn't contained in 56. I'm looking at 62 now. Except that the earthworks consent was lodged in advance of the subdivision. That's the explanation. The successful implementation of the earlier stages is firmly intact. So there's no explanation in 62 at all.
So
it just says that they were lodged in advance.
Yes, it's talking about being lodged in advance.
Yes, but it didn't say why. This is supposed to constitute the explanation as to why you had to do them separately. Then we move to 87. I looked for this very carefully in the decision, and I may have missed something, because I think we're only referred back to 62 or 56. Here we are as 87, and the purpose of the land use consent was preliminary site contouring works, which obviously it was, and to allow for focused activities within an access corridor, which I don't know what that means. Then it goes, preparing earthworks consents in advance is not uncommon. That isn't an explanation. It simply says it happens in situations approaching winter works, and as well as through guidance provided by advance, a preemptive earthworks consent. So the word preemptive, of course, alerted me immediately. Preemptive of what? Preemptive of complaint? Preemptive of what? Presents a strategic and logical undertaking common to many. With respect, none of that made any sense to me, and whether it'll become clearer. Then we had Mr. Glover, and he only talks about it at paragraph 18, I think. Let me have a look at his evidence. That's the only one you've cited. No, that's not paragraph 18. Is it his rebuttal, is it?
No, it's paragraph 18, talking about often the case that land use and subdivision consents will be applied for at the same time, but not a universal rule. On this occasion, Perjuli sought a land use consent before subdivision as a way of getting earthworks underway efficiently and pragmatically.
So where is that? I can't. I'm looking at paragraph 18. Does that start revisiting the high-level statutory documents, or is that a different paragraph?
No,
I'm in the wrong paragraph. Sorry, let me find it. I'm in the wrong place. Oh, right, yes, I have this. This is the one I marked. Perjuli sought before subdivision as a way of getting earthworks underway in an efficient and pragmatic way, favourable weather conditions. It was intended that subdivision consent would follow shortly afterwards. So the explanation we have is that it was efficient and pragmatic, and it had something to do with favourable weather conditions in March. Is that what we're to take from that?
Yes, that is correct, sir.
Because the actual work started in May, which I've always thought was either autumn or winter, depending how you viewed the world. So how was it taking advantage of the favourable summer weather?
That's to do with the nature of the works, which is perhaps something Mr. Glover can address in terms of timing.
So, with respect, I have problems with the explanations given, and it's up to the parties to address that. There are other explanations they give which are less favourable to your client, obviously. We're at 64 now.
Yes, so noting that at 64 that the stage 1 subdivision being sought by Perjuli at present involves creating a separate title for the Prendergasts who live in a dwelling on the site which doesn't at this stage have its own independent title. And Perjuli will retain the balance land and intend to apply for further subdivision consent in due course. And submitting this is not a situation where earthworks and subdivision needed to be considered together. It was appropriate for Perjuli to undertake contouring earthworks and then to consider the proposed subdivision further, which is amplified to some extent by the nature of RMA reform. And in addition to broad picture reform, we've had an Amendment Act and Council NPS responsibilities. It's acknowledged that there have been draft subdivision proposals and there's a current application on hold, as well as the stage 1 subdivision that will create a separate title for the Prendergast lot and the balance. It's acknowledged or possible that the consent authority could have sought the application to be deferred on the basis there would be other consents in future, but this was not done, and Perjuli's view was that this was not necessary. Earthworks could properly precede the finalisation of the subdivision proposal.
Thank you. I'm wondering if we're a couple of minutes early, but perhaps if we take the break before we move on to Ngāti Maru, and that's quite a large part of your next part, which I assume, being law, we'll go through. I assume so. Is that right, Mr. Gibbons?
Yes.
Yep.
I'd like to go through some
So
of that.
then we move to the evidence of Ngāti Taumanupo, and that again is a relatively, seems to me that may not be as necessary, at least blow for blow. And then you go on to case law again from 84 onwards. So I think we'll take the break now and pick up with your submissions afterwards. We seem to be a little over halfway through, so we're making relatively good progress. But I think Ngāti Maru seems to be a key decision from your perspective. Is that right?
That's correct, yes.
Thank you. We'll take the morning adjournment and recommence in 15 minutes.
To make the most of your summer, let's squeeze out every last bit of fun in the sun, because we've earned it. Don't go the usual way, try a new path, explore new places, and do something new, New Zealand.
Please be seated. So, Mr. Gibbons, I invite you to continue on with your, I think we're at 67 now. Have we got him?
Sorry, could you repeat that, please? It didn't quite come through.
Oh, there we are. Mr. Gibbons, would you like to continue? I think we're at paragraph 67, looking at the Ngāti Maru decision.
Yes, if it pleases Your Honour, I just want to raise a couple of factual points about the discussion we were just having around timing of certain events. So just noting that the application date for the consent was in late February 2020, which is tail end of summer, but the consent application process had started earlier. And hoping still to get some earthworks underway during that period, and noting also that the formal letter from Tamanupo came through in late March after the application had been done. So just wanting to note those points. Also,
well, perhaps just before we move on from that, the record that the council has of the date of receipt is the 3rd of March. Is that in dispute?
Oh, sorry. No, 3rd of March is correct. I think that's when...
And I think it was the 26th of March that the Taimanupo letter was. If somebody could just correct that for me if that's wrong. I think that's correct. As Thomas is just looking.
That is correct, Your Honour.
Yeah. So it's correct. It was given to... That's why I asked the question, did Perjuli have any duty to pass that on to the council before the decision was made? So it doesn't... That was my point. It wasn't received prior to the application, it was received after the application was made, but prior to decision, which was made, I think, on the 3rd or 4th of April, as I recall.
Thank you. So just noting those points.
So we move on to Ngāti Maru now?
Yes, thank you. So there's a small amount of comment in the decision on this Ngāti Maru decision, but simply noting no evidence or no argument was heard on that. Paragraphs 68 and 69 extracted some comments from that case, raising a question in the submissions around the relationship of that case to the relief sought by Tamanupo. Because while Tūranga Waiwai had identified an interest in the resource, the essence of Tamanupo's submissions at the review hearing, the thrust of their evidence at the review hearing was about ownership of the resource. And that raises an issue about Ngāti Maru being about a need for a decision maker to adjudicate on divergent claims as to effects under the RMA, but not touching on divergent claims to ownership, these being dealt with under other legislation. There's also a concern, moving on to paragraph 71, that the decision of the Commissioner did not effectively adjudicate on these claims. Rather, the Commissioner took the approach of stating that the support of Tūranga Waiwai for Tamanupo at a particular point in time meant their interests should be recognised, and the earthworks would not sufficiently recognise values that Tamanupo placed on the site. But the consent authority did not effectively adjudicate on these divergent claims as the appropriateness of the effects, and so in the submission didn't quite fulfil its responsibilities. It does remain apparent that Tamanupo seeks acquisition of the site. There's also comments in the more recent evidence that Tamanupo perhaps seeks alternative relief, including 74 use of the site for a public reserve or a similar use. The concern here is that Tamanupo is not the owner of the site, and such use is inconsistent with the zoning of the site at present. It it would be possible for Ngāti Tamanupo to seek a plan change to achieve a rezoning, although that would be inconsistent with the intentions of the landowner and PC 17. It's also noted that the revised conditions as proposed will set aside part of the site, including a borrow pit in perpetuity, which will achieve part of Tamanupo's goals around a public reserve or perhaps an educational facility. It's then submitted that if it's accepted Tamanupo's claim or interest is grounded in the RMA rather than purely in ownership, then following the Ngāti Maru decision, it's submitted it's necessary for the consent authority to adjudicate on divergent claims, and it's to these claims I now turn.
Right, just before you do, can I just... I'm sorry to sort of have to go back to 101, but section 6 and section 7. So, 6E, speaks about the relationship of Maori and their culture and traditions with their ancestral lands, water sites, wahitapu and other taonga.
Yes.
Now, I realise there's a dispute about wahitapu. I don't know if anyone's arguing that. It seems a difficult argument if the site's occupied, but nevertheless, taonga is clearly, but ancestral lands, water, which I presume would be the Waikato River, sites, those things clearly seem to be caught within the framework of the site for the Cape. And as I say, I have to repeat in many, many decisions, I don't know why, it's the relationship of iwi, hapu, whanau to these particular things that the court tracks. The court is not focused on ownership of them, it's focused on the relationship. Now, I don't understand the evidence of Tūranga Waiwai and Taimai Nupo, apart from the assertion of ownership, which is made as mana whenua and several witnesses. But generally, I understood that Tūranga Waiwai acknowledged that Taimai Nupo had a relationship with the site, they say going back to the 1700s and earlier, where it was the past site of Ngāriwa, I think, I'm correct in that, or Ngāiri was it? At that time, there was clearly, they were occupying that site. Then the question turns, as you'll recall the evidence, to whether they maintained ahi ka, with the evidence of the Tūranga Waiwai witnesses making it clear that they believe Ngāti Mahuta now has mana whenua there. So the current relationship, they say the ahi ka relationship is now with Ngāti Mahuta. I don't know if that is in dispute, we'll have to find out in due course. But nevertheless, those are secondary issues to the court's concern, which is about the relationship of these peoples to this area. And the reason I say that is because Tūranga Waiwai themselves accept that Taimai Nupo should have been consulted and do have a relationship with that area. So I don't know that the tangata whenua parties are as far apart as you might assume. I also understand that both are part of Tainui, and they're both part of the Kingitanga movement. Now, if that's correct, and it's a bit unclear in the evidence, but if that is correct, that would show that they are essentially related, and as part of the Kingitanga movement, of course, there's an agreement. That's why the marae, Taimai Nupo marae, made itself clear that it wasn't asserting mana whenua, for their part at least. So I wonder how far the parties are apart. If we're focused on relationship, I don't think there can really be seriously any argument that Taimai Nupo have a relationship with this area, is there? At least your witnesses don't seem to have argued that point.
So there's not an argument, there's a claimed relationship here. The nature of that relationship is discussed in the evidence in some detail.
Yes, and I don't understand even your witness to suggest that Taumainupo don't have a relationship to the site going back to the time when the pa was a key pa on the Waikato River. Now, may have the names wrong because I'm doing it all from memory rather than going back to the evidence, but it was clearly this is where the argument came about the acceptance of the child of the couple who had eloped, and that being a key point in Tainui history, and was cited in fact in detail by both the parties. And I think even your witnesses, the reports that are attached note that same record, don't they?
So they're accepting of the historical and archaeological evidence around
So to
that.
say they have no relationship with the site isn't borne out by the evidence that even your witnesses accept. They clearly have a relationship with the pa and the site around the pa. The question then is the degree of that relationship as it relates to this piece of land, and what the effects are, what are the values and effects on those values of this, rather than an argument they have no right to be here.
No, the question is, yeah, I agree, sir, that there is an understanding that there is a relationship that's claimed, and the extent of that relationship is to some extent contested. But it's understood that there is a claimed relationship here.
Yeah. So unsurprisingly to us, the assertion by Taumainupo that they are mana whenua has got a fairly strict response from Ngāti Mahuta, and I'm not sure where that's going to go. But at the end of the day, we're not here to decide who is mana whenua. We're here to decide what level of relationship both of them bear in relation to both the site and the interests in the area. Would you agree with that, for our purposes?
Yes, I do agree. I think, as the submission notes, that also comes back to the extent of the implications of that relationship, perhaps is one way of putting it. Yes. The implications of that relationship for what happens on the site in the future is, of course, a key concern of the appellant.
Well, a key issue for us, and I have discussed this with the Commissioner, so I just want to put it on the table, is that borrow pits and pits for the preservation of foods, in particular kumara, but all food types, are different things, clearly understood within Māoridom as such. Unfortunately, we're going to have to go through that evidence with the witnesses because everyone has really not dealt with that in detail. And the question as to whether you would ever store kumara next to the river is a key issue for me, having been involved in a number of cases, and I think it would be fair to say also for Commissioner Prime, who has a better understanding than I do of the way in which these things worked. So I just want to put that on the table because, of course, the argument about Ngarawahia is, of course, based upon an argument about the kumara pits being opened and what those are. And this is this issue, what is a rua versus what is a borrow pit, or a burrow pit as some people refer to them. And that's why we're interested in the topography of this land, to get an understanding of how the land would have been utilised at the time the pa was in existence and operating as a fully occupied and functioning pa. So I'm just putting it on the ground, not so much just for you, Mr. Gibbons, but for everyone to know that's what we're trying to focus on. And of course we have to take away the fairly serious depredations that have occurred as a result of the main trunk railway and the state highway to understand the topography that might have been there earlier, and we have limited information on that at the moment, obviously. So I just want to make that clear. So we're now moving to 76, the evidence of Ngāti Taumainupo, and I hope we can so probably 77 might be a good place because you're picking up on some of the same issues I've just mentioned. So A, if you just read out those in 77, unless there's something in 76 you want to cover.
Just wanted to touch on at 76 one of the points about that relationship regarding the borrow pits or the whole site, because that's one of the points that there doesn't seem to be complete clarity on. So simply make that point. I think in terms of covering paragraph 77, just wanted to broadly summarise that perhaps that there are a number of points contested in that evidence, and they're all appropriately noted there. If I could move on from those. And you've touched also, respective 78, on issues about borrow pits versus terminology of rua and so on. So I don't think there's too much that I need to go into detail on there. 79 picks up on that point around whether the site as a whole or the borrow pits on them are best appropriately seen as paid to be a taonga. And it's noted also at 79, the site has been in private ownership for many years. It's been farmed and grazed. There's an existing dwelling on site. And as noted earlier, there is a proposal to set aside part of the land in perpetuity to recognise aspects of that relationship.
Can I ask a question? And if you can't answer it, I will repeatedly ask everyone who comes before me, because somebody may be able to. I doubt that you can, but I think it's worth asking. One of the Tūranga Waiwai witnesses says the land is not Raupatu land. So as I take it, that means it wasn't land that was taken by the Crown. Is this land that was taken by the Crown in the the invasion, or seized in some subsequent process, or is it land that was never taken? Do you know?
I don't know immediately, but I would defer to some of the evidence of Tūranga Waiwai around that, and I note, just in as much as it's relevant to that relationship you've been referring to, that any confiscation would have been after the departure of Tamanupo.
Well, yes, that's why I'm wondering if it may have been in the context that the confiscation was against Ngāti Mahuta, not against Taimaenupo, and I don't know. I just thought I'd ask you the question, as I'm going to ask each council, to see if we can get any more clarity. And you don't know the answer to that precisely either.
No, but seeing Mr. Ketu nodding as if he'll be able to answer.
Yes, I'm sure, because it's part of their case. I just wondered if you knew. The construction of the rail and road appear to have occurred under the Public Works Act in one of the very early iterations back in the 1850s. So they may not have had to rely on a confiscation to do that. That's all I'm making. That's why that doesn't prove anything outright as to whether it was confiscated land or not. Because, of course, as you know, some of the Waikato land was returned afterwards as well, and it may be that is why it's not Waipatu. I just don't know the answer. That's fine. Okay, 79, is there anything? Oh, it's just 78, you were going to pick up some points in 78, weren't you? Or are you content you've covered those?
Covered those, simply noting contestations and the evidence that you've largely referred to already, sir. So,
thank you.
And similarly on 79, simply picking up on the history of private ownership, farming or grazing on the land, there being an existing dwelling, and versus the improved position under the revised conditions of setting aside part of the land in perpetuity to enhance recognition of relevant historical factors in the relationship you referred to. Paragraph 80 is simply signalling that there is a contrast between the evidence of Ngāti Tamanupo and Tūranga Waiwai, and paragraph 81 outline some of those different comments or claims in respect of Tūranga Waiwai and their view of things. So,
can I just check? The analysis that was given to us by the one of the Tūranga Waiwai kuia, I think, about the levels of ahika and the several other levels is consistent with evidence we've heard in other cases. Do you have any dispute about what is said there? I don't understand your witnesses to touch upon these issues.
No, don't dispute the evidence of Tūranga Waiwai on those points.
So this is the question of seasonal, where you have seasonal access and rights of occupation, rights that have been abandoned, and etc. There's several levels, and certainly the court the court is alert to that argument, and we've had the evidence on that in previous cases as well. So moving through B.
So 81.
Yes, okay, yes. And well, again, as I say, I don't know whether that is actually in dispute or not. We'll find out in due course. It was a little unclear whether or not the witnesses for Tai Manupo are saying they hold it as mana whenua against Ngāti Mahuta. I'm not sure if they're actually going that far, but certainly the marae sent a letter saying they didn't consider that went that far. You go at C. I don't think there's anything there. I think everyone agrees on that. So D, you might want to read that out. I'm not sure that they'll agree with you, but you better put your colours on the mast, I think.
81D is referring to the evidence of Tūranga Waiwai that
Yes.
Ngāti Tamanupo does not have mana whenua ahika o Kaitiaki tanga and Ngarawahia, and describing the interest of the Tamanupo in tikanga terms as ahi kore, simply picking up on the evidence from Tūranga Waiwai around that, talking about the whakapapa and the exertion of mana in relation to Piahua Pa, noting other points around the genesis of the name Ngarawahia, the nature of the burrow pits in and around the vicinity of the pa, and distinguishing those burrow pits from Arua, noting that some are for food storage and some are for extraction, and talking about how the location of the pits and the evidence of Tūranga Waiwai is relevant there. Nature of the site at I, noting the burrow pits within the site and not Wahitaku or Taonga, and the evidence of Tūranga Waiwai, and expressing concern that these terms not be applied lightly lest their significance be degraded. Noting at K and L, some of the background to that narrative, and while that historical narrative is acknowledged, it doesn't necessarily translate into all of what is claimed. Similarly, at paragraph 82, it's simply setting out some key matters of evidence, and I can just touch on a few key points there. 81D, C, first of all, is talking about Tūranga Waiwai's extensive involvement mana whenua matters relating to resource management over an extended period, and at D, noting their active involvement over various stages of river terraces. And
Can I just pull you up for a second there, because I was going to ask this question because, of course, without the contour map, I'm not able to tell, but you've got the witnesses there. It does appear that is there several terraces, or is it a constantly raiding? You mentioned something about a ridge through the middle of the site.
I'm sort of roughly drawing a picture with my hand. It contours down. There's effectively two levels.
That's what I thought. It looked to me as though it was two levels, which is consistent. I did Amberfield, and you can see two levels there too. So I know it's a different part of the river, but nevertheless, it's the same river. And that, of course, is historic at the times when various flows were occurring thousands of years ago. And my understanding is that there is a lower level, and the walkway is on that lowest level. Is that right?
Yes, it is.
And then it rises up to what might be called an intermediate level, which is that old paleo level going back to the time when the river was flowing somewhat higher.
Yeah, correct.
And then it lifts up again, not as much, but it lifts up to the fairly constantly from the photograph. It looks like it lifts up then fairly constantly from that terrace coming up to the state highway, and then goes relatively flat before raising up again where the power site was. Would that be fair?
Yes.
So the burrow pits are on not on the footpath, the lowest river terrace, but the old paleo terrace, I gather, where there would have been the old silts from when the river was flowing over that as bed.
Some on both is my understanding. Is that?
All of the ones that are identified are on that second terrace.
Yes, all the ones identified on that second terrace.
Yes, yeah, which was the old river terrace from whenever, I don't remember when it was flowing at that level, but you see it along much of the banks of the Waikato. And that would have had, I presume, I'm saying this so other parties can correct us if we're wrong, would have had some of the river sediments gathered on it, which I assume is what they used for growing the kumara. We'll find out in due course. But it's that terrace that we're interested in this case, that not the one right down by the river, but one that's probably, what, 3 or 4 metres above it, or less?
Probably 3 to 4.
Yeah.
As Riddling had, no? So 3 to 4 metres up.
Yeah, well, we'll find out. Hopefully Ms Riddling will get us the map in due course and we can check that contour, but it looked from what I saw to be about that, and we'll find out from the witnesses. Just
apologies for my interruption, Your Honour. I have emailed through a contour map to Ms King.
Well, can we see if we can get it up on the screen, in which case we can have a look at it and see if that tells us the answer, Ms Riddling
it
might
may
be
do. One thing I do have to say is that is from our intramap system, and I have been advised that has contours of 1 metre. That's the best we can do with our intramaps. If that's not sufficient, then please let me know.
Well, I think it'll be more than sufficient for what we're doing here. What can you tell me from looking at it? What do you think the second terrace, the height of the second terrace is? Myself or Mr Gibbons? Well, you've seen it for longer than he has. He's probably a little at sea. What do you think it is, Ms Riddling?
My understanding is that there is 2 levels. The lower level is not where the borrow pits are. The borrow pits are at the slightly higher level.
No, so it's the second terrace we're interested in, at the second. Correct. One on the property. Can you read the contours? Or no? I suppose it's just lines, is it?
So they are just lines, but you can see also on that map there are the 2 identifying marks, which are... Yeah. No, it's just that we can't see them at sufficient scale to be able to tell from that. So those 2 identifying marks include the numbers that have, or the site numbers that have been given by... Yes. No, that's helpful. It's just a question as to whether we can figure out how many metres it is and how much it raises by the time it gets to the road. Perhaps you could print some copies off for us and we'll have a closer look at that. It's really for the witnesses to confirm in due course. But thank you for that, Ms Riddling. Could we revert back to Mr Gibbons again? So I don't know if we can make much of that at this stage, Mr Gibbons, and probably it's the first time you've seen that map anyway.
Simply, noting the contouring on that and the 6 metre 15 to 21 gap between the different heights there, and then I gather another couple of metres up to the road. Right,
that sounds about what I would expect. No, that's helpful, thank you. So where do you want to pick up again? You were at D, I think.
Yes, at 82D, thank you. Noting the support of Tūranga Waiwai on the basis of certain conditions, including placement of a significant kohatu or rock with a plaque, recognising that history, and of course cessation of works if artefacts are uncovered. It's acknowledged there was some concern about a lack of consultation at some points, but Tūranga Waiwai expresses support for further engagement, and it's noted at E that the consent authority's decision to cancel the consent placed seemed significant weight on Tūranga Waiwai's support for Tamanupo. Submitting the support was temporary only and is should not be taken as permitting the consent authority to ignore the differences in approach between these 2 submitters. There is F noting the historical connection between Tamanupo and the Pa. Tūranga Waiwai's views being that this could be accommodated through the revised conditions, and noting they did not support the assertion that Borrow Pits or Waikato Tonga or the source of the name Ngaruahia. Some of those points are noted in the earlier evidence I've talked about already. Simply a comment at G on the nature of the borrow pits and noting comments around the mandate of Ngāti Tamanoko at H. Do return to that point around at I around the need for housing in the area, and to touch on a point you raised before, Sarah, there's a concern that this is not Aropatu land confiscation land, nor an area where Tūranga Waewae feels Tamanupo has mana over the whenua, and noting that their historical connections must be seen in the broader cultural and historical context in respect of determining mana. Tūranga Waewae continues to exercise mana and kaitiakitanga over the site, and Tūranga Waewae's evidence and support for the revised conditions put forward by Perjuli. There's comments there on the historian's evidence very briefly, and support from Perjuli's point of view for the evidence of Tūranga Waewae and the implications of that evidence at 85. And it's appreciated that's something that will be fleshed out before the court and other evidence. There's some comment moving on to paragraph 86 around case law and referring to Ngāti Maru at 86, talking about assessment of relative strength claims according to tikanga Māori and matauranga Māori, and linking them to discharge of obligations under the RMA and resource management outcomes. Noting comment to 87 from GOC and other cases that the RMA does not confer a power of veto over the use or development of natural physical resources in an area. Expressing concern at 88 that the decision of the consent authority could be seen to allow this power of veto without properly considering the position of Tūranga Waewae. Noting paragraph 89, comment on SKP Incorporated, and noting that the consent authority held that Tūranga Waewae's mana whenua status was not in dispute, and at paragraph 90, distinguishing some aspects of Tauranga Environmental Protection Society in relation to the emphasis on cultural effects there and how that unfolded over a period of time versus the different period of time involved here, and also the nature of the finding by the Environment Court in that case compared with the decision of the Commissioner here, expressing some points of commonality, however, around some of the comments in Tauranga Environmental Protection Society. Paragraph 91, simply briefly noting some decisions which it's accepted are in a different context around archaeological appeals, but noting that in one of those decisions there was the removal of archaeological sites to enable development of land, and in another the situation, Ngāti Porou Trust Board case, where the court has expressly considered the extent to which refusing works would restrict the reasonable future use of the site and the proportionality of not allowing development to occur. So removal or destruction even of archaeological and cultural features can be appropriate in some circumstances, is what is noted there. Commenting at 92 that the claimed cultural effects, and I appreciate you talked about the nature of a relationship, but it does seem to Perjuli that what Ngāti Tamanūpo emphasises again and again is that they're seeking ownership of the land, which is not relief under the RMA, and they are claiming that these are rua or food pits when they seem to be only borrowed pits based on at least some of the evidence, and that has implications around their association with the name Ngaruahia. And it's noted in the evidence that have been in private ownership for many years. The land has been farmed, and some of the borrow pits are modified or in fact nearly destroyed in some instances. The revised conditions mean the borrow pit in the best condition 92E will be preserved in perpetuity and be accessible by a range of different people, and this will have positive cultural effects. It's submitted as with the signage, kahatu, and other matters identified. So it's submitted at 93 that the decision to cancel the land use consent did not give proper or appropriate consideration to the nature of the interest claimed. It simply states that the site is regarded as taonga, while also acknowledging evidence the borrow pits are not wāhi tapu, and the decision does not in any place suggest the pits are rua or anything more than borrow pits, which is again the evidence before the court, largely certainly from Tūranga Waiwai, that these are borrow pits, not rua. There is comment on the difficulty with allowing a whole site. It would seem to be declared a taonga. This could have an effect on broader issues of development. It seems if we don't allow any earthworks here or any development, the consent itself will become unviable. The site would not be able to be used in a manner consistent with its new residential zoning, Plan Change 17. Other landowners may find that similar claims are made. Some sites are, of course, of cultural significance, and it would be hoped that this would be identified at the plan making time rather than later on. Here the site was not identified as being of significance prior to the rezoning, even though this went through a public planning process led by council. And there's obviously a divergence of opinion as to the appropriateness of the site as a whole for development. At least that's what it seems from the evidence. So there is a concern, the nature of the claim and the way it's been phrased prevents development in a manner consistent with the zoning and would allow floodgates issues to arise. And comment at paragraph 96 that, as you've alluded to, Sir, the decision to cancel the consent talks about the desire for more detailed consideration of iwi values. Was submitted there that there is that information before the court now to be able to make that assessment. At paragraph 97, it submitted the claims on Tūranga Waiwai to be preferred to those of Tamanupo, and there is a degree to which the Ngāti Māori decision requires an assessment of divergent iwi claims. There are issues still as to whether Tamanupo's claim is really a claim for land ownership, because that comes through very clearly in their evidence that they do want to acquire the land, perhaps more than anything else. And it's submitted that it's the evidence of Tūranga Waiwai should be preferred here. It's also submitted at 98 that based on the evidence, including those parts that are contested, consideration of the mitigation of positive effects, that no significant adverse effects on the environment will result from the exercise of the consent. It should not have been cancelled and should be reinstated on the revised conditions. I want to return then to an outline of the legal test I raised earlier, and I appreciate we've touched on that in terms of Your Honour's comments on scales. So we go through this exercise of assessing these steps, the preliminary assessment under 128 and the notice of review that occurred. When we get to section 104 of the RMA, it is submitted that the court has a lot of information before it which supports the grant of consent on appropriate conditions. Note also at 100D that there does need to be regard to whether the activity would continue to be viable. And I appreciate that we've had some discussion on the sterilisation of the site, but there are concerns about the activity not being viable if the consent is cancelled. In terms of more appropriate conditions, obviously we have some before the court, revised conditions, and we then move on to some of the mechanics of the test, and we've talked about the need for the consent authority to determine that the application contained inaccuracies, this is contested by Perjuli, then the consent authority would need to determine that these inaccuracies materially influenced the decision. And the extent of that material influence is contested based on the information in the evidence. And the court must also determine there would be significant adverse effects on the environment. And obviously the nature of those effects is something that is discussed in detail in the evidence. There seems to be consensus that none of the effects are of particular concern other than cultural effects, and that comes back to issues such as the nature of the modified borrow pits, the nature of their association with historical narratives, and the nature of the site as a whole. Emphasise again, the evidence in Tūrangawaewae supports development of the site on appropriate conditions, and a number of positive effects arise from those. We then return to the point Your Honour made about scales, and a change of consent conditions is going to be more appropriate here than cancellation of the consent. Change of conditions is preferable to cancellation, and that has some support in existing case law, which supports change of conditions over cancellation. Based on the evidence, change to the revised conditions is argued to be more appropriate than cancellation of the consent, and there's reference at paragraph 101 to the Newbury decision on the nature of consent conditions, which I'm sure the court will be familiar with. So H, paragraph 102, notes the relief sought, which is the reinstatement of the land use consent on the terms of the revised conditions, setting out these in Schedule 1, and noting that they provide for the protection of the borrow pit in perpetuity, while allowing Perjuli to proceed with the earthworks that are precursor to further development. And it's noted the grant of consent on the revised conditions, reinstatement of consent on revised conditions will accord with zoning, planning frameworks, the correct legal test, the decision of Ngāti Maru Trust and other relevant case law, the evidence before the court, both iwi and planning, the effects arising and the purpose and principles.
So can I just ask a question, and I can't remember exactly where this comes up, but one of the commissioners mentioned to me earlier that there appeared to be pits on the site that were considered to be in better condition than the others. The main argument for Perjuli seems to be that it would affect their profitability if both were protected, or if there was a wider margin than 1 metre. Where do you say that comes into the evaluation that the court's required to undertake? Is this under 104 in some way?
There's a couple of different elements to that. One would tie in with the 104 assessment around efficient use of resources. One would apply under the need to have regard to the viability of the activity. That's one of the directives in 131. It's also... But
every time I've had a case, the company always says it affects the viability if you impose a constraint on us, which is just factual. It doesn't really, there's no evidence about it being unviable, simply inconvenient and perhaps less profitable.
There is also that is a consideration for the developer, of course, the profitability of the development. But I think some of that discussion ties in with will protection of one borrow pit, the best condition borrow pit, be sufficient to mitigate adverse effects and create, in this case, positive effects, which is what is submitted.
So if I could sort of go back to the type of analysis that's been used in other cases, including mine, Blue Ridge is probably an example of one case where the power site was protected, plus the context of the power site could be understood. Here we have clear disconnection between the power site and the river. If that relationship is to be recognised in some way, it seems to me the argument would be how can we, as best we can, given the fact there's a state highway and a cemetery and a trunk line, recognise the original connection between the PAR site and the river, and the use of the alluvial soils from the river to create the food sources and food wealth, if I can put it that, of the PAR. Now, of course, we can't. In terms of this application and review, we can only deal with a small portion of land, and I accept there's an argument that it's too little, too late. But if we considered that there should be some recognition of that relationship, that might encourage us to seek some connection between the river, the lower river plateau. In other words, recognising that there was originally a connection between the river and the PAR, and recognising how that could be recognised. And we may want more than a metre around a burrow pit, for example. We may want a connection down to the river path, that type of thing, to recognise. Now, we haven't explored all the evidence, and I'm just going on what's happened in previous cases. Now, those things may require some form of redesign by the developer, but given he hasn't done the subdivision yet, I can't see the problem there. So the difficulty from our point of view is a reconfiguration of the earthworks to recognise some of these areas doesn't seem a difficult task, because we're not here evaluating the subdivision consent, we're only evaluating the earthworks consent. So in a sense, that's, I think, why Commissioner Savage might have seen that it would be better to deal with both together, because it could hardly be argued that a change to your earthwork consent has any particular effect on your client. It only affects the subdivision, it doesn't affect the earthworks. It'll cost him less to do the earthworks if we exclude some areas from it.
With a corresponding loss of yield.
No, there's no loss of yield, because the earthworks consent doesn't have any yield at all. It simply allows you to do earthworks. This is the problem. You've got caught out. And the court has made this point many times. You can't argue on a consent you've never applied for as a ground for succeeding on this consent, because this consent is an earthworks consent. It doesn't change the yield. There is no yield at all.
It impacts what can be done in future in terms of development of the land.
Well, that's why it might be better to cancel it and allow those matters to be considered at the same time.
I think also...
What I'm trying to say is, as a principle of law, on what basis could we take into account an application you haven't even had processed yet? I'm not aware that we can do that as a matter of law.
That's acknowledged that you cannot take into account an unknown subdivision. And the part of the reason for this being sought on its own is that the nature of that subdivision consent may change. There is an ability to consider lot sizes and dimensions based on the dynamic planning framework, but these earthworks will allow works to be done in advance of that proceeding. I think it's also useful to know...
The point I'm simply making is I cannot see that in considering what the appropriate way to recognise the relationship would be, if that seems to be the issue, that we would take into account the profitability for a future subdivision of the property when no application has even been filed, nevertheless even considered by the council. It might be granted. It must be at least restricted discretionary. Is it restricted discretionary or discretionary, the consent?
This consent, the earthworks...
No, subdivision consent.
That will be restricted discretionary, I believe.
Yeah, it must be at least restricted discretionary, because the Act requires it to be at least that, if not more. So that means that consent could be refused. So we can't assume that your client's going to get the yield he plans to get. Unless, of course, both applications were dealt with at the same time, which is why the court has repeatedly said in its decisions you're better off to do that than rely upon a subsequent provision. For example, the occasion when I wouldn't allow a subdivision consent at all, subsequently.
So there is a relevant factor there, Your Honour, which touches on the nature of some of the evidence and what is claimed by Ngāti Tamanupo in particular. So we do have a situation here where Tūranga Waiwa is saying setting aside one burrow pit is sufficient to acknowledge cultural effects and to create positive effects, whereas Tamanupa is saying essentially they oppose any development of the site for residential purposes.
If we get to the point that we're reviewing the consent, and that seems to be the common position of everyone, that we're at least imposing new conditions, the question would be, what are the appropriate conditions to recognise the relationship of the pā and the hapu associated with it? That would be Ngāti Mahuta and Taumanupu, it seems to me, to recognise that relationship. And I would have thought, given the history, that that relationship between the river and the pā is very clear and critical. I'm just pointing out that I don't think we can say, no, we're not going to do that, because somebody might want to apply for a subdivision that's at a particular intensity or profitability in the future.
Yes, and I think the implication of that is the nature of the cultural effects need to be understood, so the appropriate way of dealing.
I agree. Okay, well, that was the only point. Now, I think 101 you haven't covered. I don't know about Newbury. Where does Newbury come in?
Just noting that any conditions to meet the tests in 101A, the RMA and Newbury, focusing on resource management purposes, fairly and reasonably relating to the activities authorised by the consent, and not to be so unreasonable they could not be approved. So it submitted the revised consent, revised conditions.
Well, I suspect I'm going to get pressed to go a lot further than that. That's probably no surprise to you, but I'm also not going to be in the least bit surprised if the parties, possibly even Te Rangawaiwai, but certainly Taumanupu, won't say that active protection of that relationship may involve more than just protecting the Borrow Pit with nothing else. That you may also need to look at how that relates to the surrounding area, because it's the relationship of those things to the pā and to the river. I just want to give you a chance to, you may want to leave that for reply, but I'm pretty confident I'll get that argument, because I certainly get it in all the other cases. Because active protection is one of the key requirements under the treaty. Now, you say that you're not obliged to do that, and I don't know to what extent I'm obliged to do it, but I'm sure Ms Thomas at least will tell me what extent she thinks I am obliged to do it in due course. Do you want to say anything about that?
I think that does come back to at least partly to the framework Council created in zoning the site for new residential, and I think that is an important part of the framework, including that which you've alluded to. So we do have a situation where the Council went through a Council-led plan change to rezone the site to new residential, and they consulted with various parties as part of that. And I think the implication is that if it's difficult for the site to be developed at all now, that creates real concerns about that zoning.
Can I ask one final question? I can ask Mr Lester this, and perhaps it's a bit of a heads up for him. I think he was Mr Lester's the planner, is that right?
Correct.
Yeah. So, in the restricted discretionary criteria for subdivision, is cultural matters not relevant?
I'll presume.
No, he might be the best person to ask. I just wondered if you knew already. We haven't got a copy of the plan provision, so I don't know what they would have to consider. I must say I'm relatively surprised by this plan, but elsewhere the plans almost always would reserve cultural matters as one of the matters for discretion. The short point being, when you go to make your application for subdivision consent, the same arguments will come up.
Better understanding of
I ask all my questions now. Do you want to go through anything in the relief? I think you've made it fairly clear where you're coming from. I don't think you need to repeat it again unless there's some new point you want to make.
No, I think paragraphs 102 and 103 set out what is sought.
Yeah, thank you. Now, I ask all my questions on the way through, and I thank you for bearing with me. I know that you probably haven't appeared in front of me before. Those who have will know that my method is Socratic, so I find it very helpful as we go through. It doesn't mean I don't agree with what you're saying on occasion. Sometimes I do, sometimes I don't. I just need to test it. So that's the reason I do it. And I now ask the commissioners if they have any questions. I'll ask Commissioner Myers first. Did you have any questions?
No, I don't.
And perhaps if we could have Commissioner Prime join us. I don't know if he has any questions.
Yes, thank you. So I've just one question, Mr. Gibbon. Is the word rua defined anywhere? You seem to say that a borough is not a rua.
So that's simply taken from the evidence of Tūranga Waiwai. I know that for what it's worth, the internet definition of rua does talk about food pit rather than borrow pit, but we haven't entered our own evidence on that point. It's largely taken from the contested evidence between Tamailungo and Tūranga Waiwai.
Thank you. I'll probably keep my questions for them then. Thank you.
Thank you.
Yes, thank you. One of the key issues we are interested in is what was the nature of these areas on this terrace, and where would kumara and any other foods, root stock that might be grown, have been grown, and where would it have been stored. Those are key issues for the court, because they will inform us as to some of these questions. Now, whether they're, and thereby the relative importance of those areas. So I just point out that that's an issue we'll be pursuing with various witnesses through the hearing. Was there anything else, Commissioner Prime?
No, thank you, sir.
Thank you. So thank you very much, Mr. Gibbons. I think that's been a full exposition of your client's position. We're at 5 to 1 or 10 to 1 now. I wonder if we shouldn't take luncheon slightly early and commence at 2 o'clock on the dot and call your first witness. Who are you calling first, Mr. Gibbons?
Mr. Glover will be called first, too.
Thank you. Followed by, and I just want to see what the questions might be. So I'll go through sorry, I don't want to know what the questions are, just how long. So Ms. Ridling, how long are you likely to be with Mr. Glover?
At this stage, you're on it not overly long. I would have thought 20, 30 minutes at the most.
Thank you. And Mr. Ketu for the Tūranga Waiwai?
I actually don't anticipate much, if at all, any cross-examination for these next two witnesses, sir, but that will depend on the exchange.
Yes, thank you. Well, I'll put in 10. And Ms. Thomas, any estimate at this stage?
Yes, sir, it would depend on the cross-examination of counsel, but at this stage the same estimation, about 20 to 30 minutes.
Thank you. And moving to Mr. Lester, same question, Ms. Ridling?
Significantly more. You're on probably around an hour.
Thank you. Mr. Ketu?
Half an hour to an hour.
Thank you. Mr. Ketu?
The same, sir, maybe 10 minutes.
Thank you. And Ms. Thomas?
About 40, sir.
Thank you. So I don't know that we'll get through those two witnesses today. We should get relatively close. One of the things that we've found with sitting remotely like this is eye strain starts to play a part, and people do tend to feel more tired by the end of the day. It's exponentially increased if we have to wear masks, but we're avoiding that at the moment. So I don't intend to sit much past 5 unless it would take us through the entire witness. So we'll be looking to start with Mr. Glover. We should comfortably finish him and then move to Mr. Lester. Whether we'll finish him today will depend a little on whether there's any preliminary questions or answers. Did you have any preliminary questions for Mr. Glover or Mr. Lester, Mr. Gibbons?
No, not at this stage, sir.
So there might just simply be some re-examination, of course, and questions from the court. So we'll see how that goes. We'll take the luncheon adjournment now, recommence at 2 o'clock. Thank you, everyone.
Aotearoa, the water surrounds us. It breathes, sometimes slowly, sometimes violently. Know the ways of the water before you let go of the land. Kia matara.
watch your timing, okay?
Win 200K to live your free.
be the best, you've got to train. Farmer or soldier? Definitely soldier.
here's Christopher. We're going to get underway again now, so if you want to switch your cameras on. Thank you. I think we'll go ahead because Christopher is the new one.
Yeah, Mr. Gibbons, you're going to call your first witness.
Yes, thank you, Sarah. I'd like to now call the first witness, Mr. Glover. And Mr. Glover, could you state your name for the record, please?
Brent Lawrence Glover.
And can you confirm you have prepared a statement of evidence?
Sorry, just before you start, Mr. Gibbons, we haven't had the witness sworn yet. We just need to swear the witness first. Apologise. One moment.
Okay, so we're going to affirm because we have no Bible in front of you. So do you solemnly, sincerely, truly declare and affirm that the evidence you're about to give the court shall be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Thank you. Sorry, Mr. Gibbons, would you like to just go over the first part again?
Yes, thank you, sir. Can you state your name for the record?
Brent Lawrence Glover.
And can you confirm you have prepared a statement of evidence dated 29 October 2021 and a statement of rebuttal evidence dated 27 January 2022?
I confirm both those items of evidence have been prepared for me.
And these statements are true and correct to the best of your knowledge and belief?
Yes.
And do you have anything to say to reinforce anything in your evidence?
Not at this time.
Thank you. If you'll please answer any questions from my learned friends or from the court.
Ms. Ridling?
Thank you, Your Honour. Excuse me, sorry. Mr. Glover, I'd just like to ask you a few questions about your evidence. Specifically throughout your evidence, most notably probably in your first statement, your evidence in chief, you make reference to the fact that you personally undertook consultation with representatives of Ngāti Tama Inukō.
As I know them now, that's correct.
And throughout that consultation, the main point of contact remained static, even if the entity itself or the name of the entity changed in that contact. The contact remained static.
Relatively, in the early phases, there was other contact as well.
But the majority of your contact for the purposes of consultation was ki mai huirama.
Yes.
And Mr. Glover, you you state in your evidence that your consultation with Tamo Inukō commenced approximately in 2017.
Yes.
And that was in relation to stage 5.
That's correct. Post-consent stage 5, the council introduced them to us.
And so that consultation post-consent included Perjuli seeking agreement from Tamo Inukō?
No, we were enforcing the agreements and conditions of consent already made and issued.
But you state in your evidence, and this is at page 26 of the bundle, or page paragraph 13 of your evidence in chief, you state that you attended an on-site meeting on the 14th of August 2017. You attended an on-site meeting with trust representatives, and there was an agreement on signage, rock plaque, and site blessing attendance, same as Tūranga Waiwai agreement.
Correct.
And you then, on the 5th of the 9th, 2017, you sent an email requiring written confirmation of agreement.
Yes.
So in respect to the consultation that you undertook on stage 5, you did seek agreement from Tamo Inukō in relation to those matters.
In effect, yes, we sought endorsement.
Yeah. And you invited Tamo Inukō, or at least the representatives of Tamo Inukō, to the site blessings?
Yes, that's all on evidence.
You sought confirmation letters from them?
Yes.
And you forwarded them signage details?
Yes.
And this consultation with Tamo Inukō, or at least their representatives, was in parallel with Tūranga Waiwai?
Was most of our, probably all of our discussions and consultation with Tūranga Waiwai.
But you sought separate agreement with Tamo Inukō as well as agreement with Tūranga Waiwai?
We involved them post in the process, but there was no requirement for that.
No, but you required or you requested agreement from Tamo Inukō in addition to the agreement with Tūranga Waiwai?
Yes, they requested confirmation.
Yeah. So your consultation with Tamo Inukō in relation to stage 5 was as a separate entity from Tūranga Waiwai?
No, at that stage it was a marae, I think, and the confirmation letter came on that letter.
Sorry?
Confirmation, this is kind of confusion, at that time came on a marae letter, not Tamanapa.
No, but you sought confirmation from an entity that we now know as Tamo Inoko, and it was the same representative throughout, being Ki Mai Huirama, you sought separate agreement from that entity as a side to agreement with Tūranga Waiwai.
Correct.
So then we move forward to stage 6, and I believe it was the 18th of September 2019, you state that there was correspondence between parties regarding meeting on site to discuss the stage 6 new consent.
Yes.
So when you say correspondence between parties, that included correspondence to Ki Mai Huirama as the representative of Tamo Inoko, or the entity that it was at that point in time.
Yes.
And again, your consultation in terms of stage 6 included meetings on site, discussions around the new stage 6.
Yes.
Yep. And you talked about site archaeology, and again you actually discussed the borrow pits at that point.
Yes, we talked about a number of issues, including the borrow pits, and had some desire for a link down to the river. That's from our perspective, not from their perspective.
And again, that consultation was carried out with Tūranga Waiwai, with Tamo Inoko, or the entity that it was known as at that point in time, in addition to your consultation with Tūranga Waiwai.
Yes.
So for the purposes of consultation, Perjuli had identified that there was an entity as separate to Tūranga Waiwai, which you undertook consultation with.
The council made us aware of that as well.
Sorry?
Yes, that's correct.
Thank you. Mr. Glover, you state in your evidence, and this is at page 27 of the bundle, that on the 26th of February 2020, you received an email from Ki Mai Huirama, who you accept as being the constant representative, irrespective of the change in entities' names, regarding the cultural significance of the borrow pits.
Yes, that's what my evidence stated. I've received a number of emails from her with changing positions throughout that period.
But on that date, on the 26th of February 2020, you received an email from Ki Mai Huirama regarding the cultural significance of the borrow pits.
Yes, that's what my evidence states.
And she advised in that email that the matter would be taken to their Board of Trustees on the 15th of March.
Correct.
And some 5 days later, on the 2nd of March 2020, Council received the application for resource consent.
The application had already been made out and processed with our planners some time before that. That's when the council received it.
But the council, yes, so the council received the application on the 2nd of March 2020.
I don't have that evidence, but I understand that it was about that date.
So if you would look at, do you have access to the bundle, Mr. Glover?
Yes.
So if you could have a look at page 702 of the bundle, which is tab 32.
That's that one. I think if you're establishing a date, we established it earlier on this morning as the 3rd of the 3rd.
Sorry?
Did we not establish it as the 3rd of the 3rd when the council received it?
Yes, the date was the 2nd of March. Do you accept that?
I accept that.
Okay, so that document is the resource consent application form that was lodged by Perjuli.
Correct.
And if you turn to page 706 of that bundle,
Sorry, say again?
Sorry, 707 of the bundle.
Yes.
The date of that signature is the 2nd of March, 2020.
Yes, that's our agent's signature.
Yeah. And that date was the 2nd of March, the same date as it was received.
Correct.
So, Mr. Glover, do you then acknowledge that there is no reference to tamo inoko in that application that was received by council?
Not directly. There was notification regards we had undertaken an iwi consultation, I understand.
But there was no reference specifically to tamo inoko.
I didn't fill out the application, so I'd have to reread it.
Do you accept, though, that there is reference to iwi consultation, there is reference to tūranga waiwai, but there is no reference to tūranga waiwai specifically within that document? The compliance document.
In the document.
Sorry?
I assume you meant there's no reference to tama inoko in that document.
Correct.
Yes, I accept that based on the evidence that's been given, but certainly I didn't fill it out. No.
But it was filed on behalf of you as, or your company as Perjuli.
Yes.
So do you then accept, Mr. Glover, that despite Perjuli treating tamo inoko as an entity in its own right, carrying out consultation with it as a separate entity to tūranga waiwai, there should have been a reference to that entity in terms of consultation that was carried out by Perjuli?
No.
You don't accept that?
No.
But you do accept that there was consultation carried out with tamo inoko as an entity separate to tūranga waiwai?
Yes, and it was an ongoing consultation.
Pardon?
Yes, and it has been an ongoing consultation over a long period of time.
And that consultation, or that specific consultation with Perjuli, with tamo inoko, was not brought to the attention of council within your consent application?
There was no conclusion to bring to their attention.
The requirement isn't conclusion, Mr. Glover. The requirement is that any consultation that is carried out is highlighted within the AEE. You accept that there was consultation with tamo inoko?
I accept there was consultation, but I'm not aware of the rules as to...
No, but you accept that there was consultation with tamo inoko?
And at the pre-app meeting, we disclosed that to the council at that time.
Mr. Glover, I'm not asking you about the pre-app. Do you accept that there was consultation with tamo inoko?
Yes, I've said that a number of times.
And you accept that the consultation with tamo inoko was not included in the application for resource consent?
No, but the council had been notified we were in consultation in that pre-app meeting.
But Perjuli did not indicate to council that they had carried out any consultation separately?
Not on that application.
Thank you. No further questions, Your Honour.
Sorry, thank you. Mr. Ketu?
Nothing wrong with that.
Thank you. Ms. Thomas?
can he see me? Tēnā koe, Mr. Glover. Just have to bear with me a little bit. I can't see the screen, so I'm talking straight to a camera. So if I look somewhere else a little bit, it's not that I'm not trying to look in your direction. Now, as you know, I'm the lawyer looking after Ngāti Tamanupō in these proceedings, and I have a number of questions that relate to both your first statement and then your reply statement, which I understand are tab 2 and 6. So I'll work between those, but try to structure it so it does follow your evidence. So at the beginning of your statement, and a number of times throughout your first statement, you refer to the Ngārua Wāhia community. And I just wondered, who are you actually referring to when you say Ngārua Wāhia community? An example is paragraph 4 of your statement.
I suppose the community would be the surrounding area of the township and its people.
And so this would include Ngāti Tamanupō.
If they're domiciled in that area, I would assume say yes.
And I wonder, because at paragraph 4 there you say that approximately 217 separate titles have been created in the stage up to 5, and then in stage 6 there's another 39, is that correct?
That's enough, I think, yes. Yes.
I wonder if you had any idea or data to show if any of the Tamanupō received any of those titles.
It's not data that we collect. I mean, basically they're sold on the open market, like most subdivisions.
And that's okay if you can't provide the information. I just thought I'd ask, because in paragraph 43, at the end of that first statement, you say almost every day I get inquiry from potential purchasers within the River Terrace. That's what you say there?
That's true.
Who exactly are these inquiries from, do you know?
Most of them are telephone inquiries from various people living throughout the region and or builder developers.
Within the region of Ngārua Wāhia or the wider Waikato region or something else?
Both, yes. Ngārua Wāhia.
Do you know if any of those inquiries are from Ngāti Tamanupō?
That's not something we collect as a part of our database.
That's fine. Now, my friend has taken you through the consultation or engagement process that's gone into the application, and I did want to just touch on that a little bit as well, because I think it's quite helpful in your statement at paragraph 26, where you set out a very helpful time frame with specific dates of that consultation and engagement. And my friend has taken you through a number of those events, emails, meetings that you've listed. And I don't propose to go over all of those again, but I did want to just highlight that you yourself say at paragraph 14 that this has been an extensive engagement. That's what you say there?
Right.
And that's made up of all those dates that you list there, at least 3 meetings on site with Ngāti Tamanupō representatives, emails, and you even say that that's not the full extent of the engagement and the consultation that you have had with Ngāti Tamanupō. Is that correct?
Certainly in post-protest, probably even more so.
Yes, and in your words, extensive engagement. And so then when the application was made, and we've now established the date of 2nd of March 2020, there was a choice made to not include that extensive engagement with Ngāti Tamaunupō. Is that right?
Because there was no conclusion and the discussions were still ongoing, there was nothing concrete to submit.
Well, there was engagement and discussions still occurring with Tūranga Waiwai, isn't that right?
No, we had a letter from them with an outcome.
So after 2nd of March 2020, you had no further engagement with Tūranga Waiwai whatsoever?
Oh, we were still in communication about timelines, etc., that were going on, but we actually had a letter of commitment from them.
Yes, so discussions were still occurring with Tūranga Waiwai, and you decided to include them in the application.
When you say discussions, it's like methodology and dealing with parties that we try and keep them informed throughout the process. So that's been from stage one right through to where we are today. It wasn't by exclusion.
Well, however you would like to label that, Mr. Glover, the decision was made to include reference to Tūranga Waiwai Marae, and the decision was made to not include the extensive engagement you had with Ngāti Tamaunupō.
We included the outcome from Tūranga Waiwai, and we were quite aware that the council were aware of Tamaunupō, or whatever name they were at the time, Marae, were being consulted with. We told the council that at the pre-app meeting.
And you do mention the council quite a bit on that issue. Paragraph 12 and paragraph 22 are examples saying that, if I read one of them out, I know enough about resource consent processes to know that council could have sought more information on consultation before issuing the consent. Council didn't, but also, Mr. Glover, you could have provided that information. Isn't that right?
Again, with the benefit of hindsight, like most good decisions, it may have been possible, I'm not sure, to have said that we had ongoing consultation, but it was not, as I say, there was no conclusion to provide.
I'll ask one more question on this and then I'll move on, because you could have provided the information, Mr. Glover, just like you have in the statement, and the decision was made not to.
I don't think it was a conscious decision made not to. It just wasn't included.
Okay, that's fine. I'll leave it there. Actually, just last on this issue of engagement and consultation. At paragraph 38, you say, I was very surprised when the Commissioner decided to cancel the consent. You go on to say it seemed that the section 428 report had been ignored. The further engagement that had resulted in revised consent conditions had been ignored. The zoning and the viability of the project had been ignored. Would you be surprised to learn that Ngāti Tamaunupō were also surprised when there was no mention whatsoever of Ngāti Tamaunupō within that application, essentially being ignored too, Mr. Glover?
Sorry, I'm not sure what you're asking me there, or whether you were making a statement.
That's fine. I'll move on to the next point. It's a matter that your council addressed in his submissions about the uncertain status of Ngāti Tamaunupō. And I wrote down what the comments were, that Perjuli can make a unilateral decision to decide whether or not to include an interested party in the application, and that's essentially what we're talking about. And it's clear in your evidence that you have preferred and you favour Tūranga Waiwai. Is that correct?
Certainly Tūranga Waiwai's support has been comprehensive, and we've taken that into account, the conclusion we got to there as part of our application.
So you wouldn't agree that you have preferred or favoured Tūranga Waiwai?
Not in any particular way. As I say, we never got to a conclusion and still haven't with Tāmanipo.
Well, if I could take you to paragraph 14 of your statement, Mr. Glover, it says there, from my perspective, Perjuli has always treated Tūranga Waiwai Board of Trustees as the main iwi group to consult with. Is that not preference or favour, Mr. Glover?
Maybe it was partly because they had been through the process and journey with us, and Tāmanipo only got introduced to us at the end of stage 5 consent process.
But you do say that you have always treated them as the main iwi group.
Well, initially they were the only group that were council basically introduced us to be involved in the project.
Well, let's just be clear with this wording, because it is your evidence here, Mr. Glover. You say always. You don't say at the beginning. You don't say in the middle or at the end. You say you have always treated Tūranga Waiwai as the main iwi group. Yes or no?
Yes.
And on that relationship, which started, as set out in your timeline in 2013, you described the relationship you do have with Tūranga Waiwai. At paragraph 32, you say that Perjuli continued to have good levels of dialogue, engagement and mutual respect with Tūranga Waiwai. That's what you say there?
Yes.
And paragraph 37, you go on to say that there is a great degree of mutual respect between Perjuli and Tūranga Waiwai. We recognise their strong history and mana in the area, and they are a professional group who engages constructively and is clear on the scope and limits of the RMA process. That's what you say there?
Yes.
So are you saying, Mr. Glover, that Ngāti Tamainu Pō, and despite not considering my client's position on whether or not you should have an opinion on this, are you saying that Ngāti Tamainu Pō don't have strong history or mana within the area?
No.
They don't?
No, I'm not saying that.
Oh. Okay. You'll be aware that some of my clients' evidence has been written in Te Reo Māori.
Yes.
And some of that history and the mana that they speak of has been provided in Te Reo Māori.
Yes, yeah.
So I'm just interested to know how you... Oh, do you speak Te Reo Māori, Mr. Glover?
No.
So how have you understood that part of my client's evidence?
We generally involve consultants or experts in those fields, because that's not my area of expertise. I'm an engineer.
Mm. But you've offered an opinion, and you say that the strong history and mana of Tūranga Waiwai in the area. But how
Yes,
can you consider my client's evidence that's written in Te Reo Māori if you don't understand those sections of the evidence?
I suppose that's reflecting upon my experience in dealing with them over a long
Okay,
period.
so not the evidence. And
Sorry?
so not, it's with your engagements and your discussions with my clients rather than the written evidence that's been filed.
The written evidence that they've given me, certainly, which was in English, certainly helps.
And when we talk about iwi, hapu, relationships, or whakapapa, to an area, do you think matters like the ability to engage constructively is a consideration?
In what regard?
To determine an iwi grouping or a Māori grouping's relationship, connection, whakapapa to the land, to the area. Do you think a consideration is the ability to engage constructively, the understanding of the scope and the limit of the RMA process, whether they are professional? Are these matters to be taken into consideration when assessing the relationship a Māori group has to the land?
It's not really my area of expertise.
But you do offer comments on those, Mr. Glover.
I think perhaps the comment is around some of the frustration of the changing objectives of taumanapo along that period of time.
And just to finalise this line of questioning on uncertain status argument, at paragraph 22 of your reply evidence, your rebuttal evidence, you say that you think Ngāti Tama Inupo wants to increase its status. So do you agree they do have some status? What is it are you referring to there?
Well, as per their introduction to us, they didn't seem to have any status in this sort of realm. So stage 4, we didn't know their existence. Stage 5, and it's increasingly, I suppose, from a status point of view, become evident.
So you didn't think that they had status, yet you sought out an agreement with them? There were numerous site meetings, numerous correspondence, extensive engagement, your own words. If you didn't think they had status, why were you actively seeking their consultation?
In the same way we do with most community groups, we try and involve everybody. If we can get outcomes that are beneficial to everybody, it's going to be the best outcome.
Okay, I'll leave that there. And I just wanted to get one point of clarification in your main statement at paragraph 7. And this is around the Prendergrass issue. Just to be clear, at paragraph 9 you say, I don't want the Prendergrass interest to be forgotten. And I just want to be clear that Ngāti Tamanupō haven't forgotten the Prendergrass interest. In fact, in the conversations they have had with Perjuli, that interest has always been recognised.
They have recognised the Prendergrass issue, yes.
Thank you. And now I want to move on to the nature of the pits. So if we could just turn to your rebuttal evidence. Now at paragraph 2, you say, I have always understood that the two are, you're referring to rua and borrow pits here. I have always understood that the two are distinct and that the term rua refers to food pits, while borrow pits, also known as borrow pits, are instead pits from which material is taken from to shift elsewhere. That's what you say there?
Great.
Now, because you've said, I have always understood, my question is, where have you got this definition or understanding from, Mr. Glover?
From probably two parties, one being the archaeologist and his investigations, and secondly from an iwi consultant that we utilise for different matters.
And who is that iwi consultant?
We have to, I'm not sure the name of his business, but we, in other subdivisions we use different consultants for that type of stuff.
And he or she, the iwi consultant, provided you a definition of rua?
In conversation, I would suggest, not a written definition.
Okay, and you would have heard the conversations between His Honour and my friend this morning that that's an issue for this proceeding, is the definition of rua. So I was interested to know where you got that definition from and the conclusion that you draw. So your understanding is that rua is a food pit?
Yes, and again, I'm no expert, so as I've stated there, it's my understanding from limited knowledge I have.
Thank you. And then further on in paragraph 3, you say that I do not believe these can be considered rua, and there are more than 7 borrow pits in the area, including a number within the vicinity of the site. Just to be very, very clear, that on the site, that's the matter of this proceeding, there are 7 rua, or borrow pits, yes?
There aren't any more.
Well, if we go to the the attachment that's provided B1, page 772.
Yes.
I'm not sure what B1 and B2, we've had everything put into folders.
Oh,
so.
sorry, sir, it is tab 37? Yes, thank you, Commissioner.
Yes.
And this is titled the borrow pit photo.
True.
And it is the attachment to the reply evidence of Mr. Lester. Yes?
I think it's an attachment to my evidence.
Oh, my apologies, Mr. Glover. And in this plan, there are 7 pits, as they're noted on the plan. Pit 1 to pit 7.
Location of where the pits was supposed to be. If you look at the photos, you can see a number of them either been filled or destroyed.
But when we are talking about this site, we are talking about the 7 pits.
Correct.
And when you talk about the pits there in your evidence at paragraph 4, you say that of the pits left, 4 or 5 of them were effectively destroyed by farming activities. 1 of the 7 is contaminated with bricks and debris, and just 1, in your opinion, of the 7 pits is in a condition to be protected. That's what you say there?
Correct.
Now, just because the pit, and you've provided photos, thank you for that, has brick or debris, that doesn't mean that the cultural significance of that borrow pit or the rua is not there. The cultural significance remains. Sorry, did you say yes or no? I didn't hear that.
Oh, was that a question? I thought you
Yes,
were
sorry. It doesn't matter if some of the borrow pit has been partially destroyed or if there's brick or debris. You say contaminated with brick or debris. This doesn't take away from the cultural significance that they have to the iwi grouping, Ngāti Tamainu in this instance, for my clients.
You have to ask that question to the iwi groups. I'm not an expert on that.
Okay.
You made a statement rather than asked a question, and he doesn't agree with the statement.
That's fine. If I could take you back to your main statement again, Mr. Glover, paragraph 41. And this, you're talking about the proposed revised conditions, the revised conditions. And you say that my expectation is that it will be vested in council in the future and be publicly accessible. Why is it your expectation that it would be vested in council? And not if you support Tūranga Waiwai as mana whenua with Tūranga Waiwai?
I think that's a practicality of the use and the maintenance of it. I'm open to how it comes there.
Okay. My last question or line of questioning for you, Mr. Glover, is around the discussions on potential purchase of the land. Both yourself and Ms. Huirama have talked about this in your evidence. And to be clear, if we could return to your rebuttal evidence at paragraph 20. And you've put the heading, what Ngāti Tamainupō wants. And you've outlined there Ms. Huirama's requests to the Crown or the Council for assistance to purchase the land. While Perjuli has been open to considering a sale that is outside the RMA and consenting process. And you go on to talk about that there. To be clear, Perjuli have been open to selling the land if there was money there available for Ngāti Tamainupō to purchase it, aren't you?
We're open to selling the land, whether it be council, Crown, Tūranga Waiwai or Ngāti Tamainupō. We're open to any of those opportunities. Obviously, in the situation it is, if we could sell the land for an outcome to benefit, we don't mind who that is too, effectively.
And you have been in direct discussions with Ngāti Tamainupō on that point, providing a price, letters that Ngāti Tamainupō can provide to Te Arawhiti, Crown agencies, for that sole purpose of Ngāti Tamainupō seeking funding to purchase the land.
Yes, we had discussions around them going to the council and what the piece of land would cost, and we confirmed that, yes. Going to Crown and or council and what that would cost.
And no, I think I'll leave it there, sir. Thank you. That's all my questions, Mr. Glover.
Thank you.
Thank you, Mr. Gibbons. Did you have any re-examination?
No, I didn't, sir.
Thank you. Commissioner Myers, did you have any questions?
Yes, I do. Good afternoon, Mr. Glover. I'm Commissioner Myers. I'm not sure whether I can ask you or Mr. Lester about the archaeology report that was commissioned. You may not be able to answer questions about it, but I'll ask anyway. In the archaeology report, and this is page 521 in the common bundle.
Sorry, sir, it's Mr. Kitu here. We're just having trouble hearing the Commissioner at the moment.
Have I got the wrong one on?
That one there.
Sorry, apologies for
Thank
that.
you. Thank you.
I pressed the wrong button, sorry about that. Okay, cool. Yep, I'll move around, I'll just shift myself around.
You've been asked about the archaeological report for stage 6. Starts around 500, and you were directed to which page?
So it's page 521, and it has a section 7 assessment of effects. And in this, it talks about the development proposal is for a residential development with 32 residential lots. And then it goes on to say, and a reserve of around 4,141 metres squared to preserve 2 borrow pits and surrounding horticultural remains. I'm just interested in knowing whether the information from this archaeology report and how it was used to input into the assessment of effects for the actual development.
I'd have to read the report. It was a tab.
Sorry, it's tab 16.
Thank you.
Chapter 7, page 521.
So this is assessment of archaeological values, River Terraces, stage 6.
Yes, that's it now, thank you.
And then if you go to page 521, it's actually page 28 of the archaeological report, if that helps.
Yes, thank you.
And it's got a section 7, which is assessment of effects. So it's just a brief paragraph, and it talks about preserving two borrow pits and surrounding horticultural remains.
Well, over a 4,141 metres square.
Yes, yeah, I think there was a number of options tossed around at different times between 1 borrow pit, 2 borrow pits, 7 borrow pits, etc. And obviously there was a number of sort of design plans thrown at that. And he's obviously picked up on the 2 somewhere, but there wasn't.
This is prepared in October 2021, Mr.
Yes, this is
focus not. And if you look at page 496, you'll see the diagram showing the area that he recommends should be reserved. This isn't a general discussion. This is a report with a recommendation, and it appears to have been addressed to you. We might be incorrect. Did you not commission this report?
Yes, we commissioned the report, sir.
And it discusses an archaeological consent, 2020/519, to undertake development conditions. So it appears to have been prepared after that was issued, or at least prior. I'm not exactly sure if it's the same site or another site.
Yes, he prepared a report that was put with the consent application, and this was subsequent, and currently the works were stopped, but he was halfway through the archaeological investigation. And I think,
with respect, again, you need to look at the document. The document attaches to it a copy of the consent granted on the 25th of March 2020. The report wasn't finalised until later. The short point is the recommendation. The only recommendation we can find in respect to the archaeological and cultural issues is this recommendation for 4141 preserving the 2 borrow pits there, as shown in the diagram on 496. Have you never seen this report before?
yes, I have, but as I said, there was a number of, there was draft reports with 1, there was some with 2.
Well, we don't have those. We only have the signed one. So,
yes.
Are you denying that that's the report that was provided to you?
No.
Well, then why are you prevaricating about answering the point that the recommendation to you is for 4141 metres squared with 2 borrow pits preserved?
On this report, that is the recommendation.
Carry on.
Okay, thank you. I just had a question. The timeline that's in your primary statement of evidence, I'll just go back to that. So that's on page 26 of the Common Bundle, so it's your paragraph 13, and it's just over the page. And under stage 6, there was a meeting on site on the 16th of the 10th, 2019, around site archaeology, borrow pits, desire for a link from the power site down to the river. And I can't find any more discussion about that. And I wondered where did that discussion go around trying to find that link between the power site on, considering that the power site's not on the site, but providing that link down to the river?
Yes, that was a discussion that we preempted and said that, you know, ideally that would be good to have, but we didn't have the capacity, obviously, to be able to link from our side to the power. A, because we don't own that land, and B, because of the rail line and the state highway. But we were, as part of mitigation, we were saying if there was a desire for that link, we could talk to the council and try and assist that as well, having already provided a link at stage 5 down to the river.
Okay, thank you. So stage 5, there is some sort of link, is there, provided?
Yes, the route goes down adjacent to the river along with the walkway and links up to the cycleway system and river system.
Okay, thank you. I don't have any more questions. Thank you.
Thank you. Commissioner Prime, if he could be joined in, please, so we can see him.
No questions. Thank you,
No
sir.
questions. So I really want to start with this archaeological report. I must say the court, sorry, if we could go back to Mr. We've lost the witness. One moment. Right, sorry. I really want to start with this archaeological report because I must say the court was somewhat surprised that no cultural or archaeological evidence was given for Perjuli. The only report we seem to have that discusses these matters in detail is Mr. Gumley's report, which is the tab 16 we've just referred to. Is there some other archaeological or cultural report that Perjuli prepared?
The initial archaeological report with the application, which Mr. Gumley prepared as well.
So what part of, sorry, I need to turn that up. What part of the application do you say Mr. Gumley prepared?
Unless it's attached to the application information, it may not have been included. We can arrange a copy of that.
Well, I'd like you to show me. I can't find anything attached of that sort. If it was attached, then there's an ESP report and drawings which we weren't given for some reason. There's a dust management plan we weren't given. And for some reason it's called iwi Constellation and CIA, but those are the two letters from Tūranga Waiwai. What other information do you say was supplied?
I don't know whether it was supplied to the court. I'd have to check on that, but there was definitely an archaeological report with the application.
And that wasn't the one that we've just referred to?
No, that's the subsequent one. As you stated, sir, the date being October 21.
Well, I can't see anything in this, so you'll have to show me where in the application you provided an archaeological report. It's not referred to in the contents. So where was it provided?
I'll have to refer to Mr. Lester and
right. Well, for the moment, assuming that the report of the archaeological report, which you provided, I might add, wasn't provided by somebody else, is the one of Mr. Gumley's, that recommends providing 4.1 of reserve. And have you read the report?
Yes, sir.
Are you aware that he goes into some detail as to its cultural value at the bottom of page 27 of the report? That it's undoubtedly part of a wider cultural landscape centred on the junction of the two main river systems in the Waikato. The archaeological evidence supports that there were over 7,000 borrow pits, and I'm not going to go on and on and on, but it says there are 3 of them left. One is at the Ngarawahia Golf Course, which we saw in looking at some of the photos. Another on the right bank opposite the town immediately upstream of Tūranga Waiwai, and one 500 metres upstream on the right bank, the 47 borrow pits, S14106. The river terraces is typical of the archaeological sites forming the basin, and he goes on at 8 to say why he makes the recommendation he does, essentially reflecting many of the points that are made by Taumanupo about the rarity of being an example of these type of features, and that's why he recommends the reserve. Why was it that the applicant decided not to go with that recommendation?
This was post our S42, is it, for the commissioners hearing. We were all talking about one borrow pit.
I see. So I want to now go through the dates and times because they are of considerable concern to me. You met on the 20th of February. This is paragraph, oh sorry, it's called stages, page 27 of your evidence in chief. You met at Cole Crescent with KH, which I presume to be Mr. Huirima, is that right? Or Rama, sorry?
That's very right, that's correct.
Yeah. And additional representatives. Were they other members of Taimanupo or were they somebody else?
I think from memory there was another representative of our business and Taimanupo.
Thank you. And then similar discussions to previous site meetings. So you'd had a previous meeting?
Correct.
Shown as the 31st of the 10th, 2019. And BG, that's yourself, isn't it?
Yes.
Advice that planning and archaeological investigations were ongoing and we would continue our dialogue.
That's correct.
Right, so the court's clear understanding from that is you were saying let's carry on discussions in the meantime, nothing has been decided.
Correct.
And then on the 26th of February, there was an email from you confirming those site discussions and then saying that the Historic Places application had been made.
Yes.
Now, you said that you hadn't made decisions in the previous matter and then you say on the 26th that you'd made the application.
The previous one says that we were continuing dialogue, so that we hadn't made any decisions.
Well, no, it says planning and archaeological investigations were ongoing.
Yes.
And then on the 26th of the 2nd, you got a response from Ms. Huirama saying that they had significance and they would be a presentation to their Board of Trustees on the 15th of March for a formal position.
Yes.
On the 28th, you filed the application. You say, according to the thing, it was filed on the 2nd of March. I don't know if anything turns on that. But 2 days after it was filed, you replied to Ms. Huirama advising that you were continuing with the investigations in the interim and that you would await the trustee board feedback. You didn't advise them that you'd made the application.
No.
Was that deliberate?
No. We'd been round in circles with them for a period of 6 or 7 months and with no outcomes, and we were trying to process the application so we could meet that summer period that we'd been talking about for earthworks.
So on the date that you filed the application, you're aware that you had told that the trustees had told you that they were going to have a meeting for a formal position, and yet there's no disclosing of that in the application.
I think there was a crossover there between me continuing dialogue and the planners preparing all the, you're seeing these as a definite date and time, whereas in behind that there's a whole lot of planning going on for quite a period, 2 to 3 months.
Did you give instructions for the application to be filed? It has your name on it, although Mr. Lester signed it. Did he not get your instructions to file it?
Yes.
I've never. Do you typically advise people to file things without authorising the actual filing yourself?
We authorise them to prepare the application and all the information required.
No, my question's very specific. I was in this area for a long time. Are you saying that you never instruct them when they actually file, you never give a formal instruction to file them?
Not a formal instruction, no.
Do you give them an oral instruction over the phone?
We give them an oral instruction sometime before, saying, but we don't, like on the day or the week, say, yes, definitely file it this week.
So at the time you were having the discussions with Ms. Huirama, you'd already given instructions to file the proceedings, to the application?
Yes.
Okay. Do you know the difference between an application for an earthworks consent and a subdivision consent?
Sorry, can you say that again?
Again, it seems to me obvious that if you're in the business of development, you would know the difference between an earthworks consent and a subdivision consent.
Yes, very much so.
The application is definitely for an earthworks consent, isn't it?
Yes.
It specifically says it's not a subdivision consent.
Yes.
So why do you refer to it as a land use consent for subdivision earthworks?
Because it's a land use consent and the earthworks are preparing it for subdivision.
Well, I'm interested in where that's discussed because the application doesn't say it is that. All it says is that it's an application for earthworks. It's a land use consent, it's discretionary, and it then says, because you have to say what it is, earthworks consent, see attached.
Yes.
So where is it a subdivision earthworks consent?
Well, specifically, I suppose it wasn't stated that council were very aware of that because of the pre-act Act, and pretty normal process for us.
What, not to say what sort of consent it is?
No, to apply for land use consent earthworks and subsequently once a week.
I'm interested in this. How many of the previous stages had you applied for separately for the earthworks consent?
I think there was at least one of the stages, again, based around trying to get the earthworks done in reasonable conditions because of the sensitive silk materials on the I suppose the platform could only really be done in summer, and you have to stop earthworks, I think, I can't remember the exact date, but basically June every year. So the idea is to try and, generally in subdivisions, is to try and get as much earthworks as you can get done in the summer period to that end of June to prepare so you can then, the next summer, build whatever you want on top of those earthworks.
So when is winter in the Waikato?
I think the winter seasons is June through to October is when earthworks are basically closed down unless you get a winter consent.
Okay.
We had hoped to start these earthworks back in November, December.
Thank you. Any questions arising? No? Thank you very much, Mr. Glover. Mr. Gibbons, I think we may as well move to your next witness. We won't complete him before this evening, or we may, but we may as well continue on. Madam Registrar, would you like to swear Mr. Lester?
Do you solemnly, sincerely, truly declare and affirm that the evidence you're about to give this court shall be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Mr. Gibbons?
Mr. Lester, could you please state your full name for the record?
Timothy John Lester.
And have you prepared a statement of evidence dated 29 October 2021 on the statement of rebuttal dated 27 January 2022?
Yes, I have.
And do you have the qualifications and experience set out in paragraphs 1 to 2 of your statement?
Yes, I do.
Is the statement true and correct to the best of your knowledge?
Yes, it is.
And do you have anything to say to reinforce your evidence?
No, I don't.
Thank you. If you could please answer any questions from my learned friends or from me.
Thank you. Same order. Ms. Ridling first.
Thank you, Your Honour. Good afternoon, Mr. Lester. As you may have worked out, I am the solicitor acting on behalf of Waikato District Council. I'm just going to ask you a few questions in relation to your evidence. The questions do swing between your evidence in chief and your rebuttal evidence. So I will make reference to the page numbers or the tab numbers to keep you sort of abreast of that. So let's just start off. Throughout your evidence, Mr. Lester, this is both your evidence in chief and your rebuttal evidence. You make numerous references to what the term is PC17. So in particular, paragraphs 8, so this is in relation to your evidence in chief at this point, in particular paragraphs 18 to 25, which are pages 4 to 6 of the bundle. You provide evidence as to the process which was undertaken in terms of the adoption of PC 17.
Yes.
And within that process, do you accept that the process of PC 17 was to rezone those sites, particularly our site, 5851 Great South Road?
No, there was other growth areas identified in the district, Telbury, one, as well as the stages 1 through to 5 sites as well, also being rezoned from rural to residential.
Yes, apologies, perhaps I didn't formulate my question appropriately. Do you accept that part of the process of PC 17 was, in amongst other sites, to rezone the site that we know as 5851 Great South Road?
Yes.
And that was rezoned as being suitable for residential purposes?
Yes.
And do you accept that the process of a plan change, Mr. Lester, is simply to identify that an area may be suitable for the proposed zoning?
I wouldn't simplify it down to that level, but provision of infrastructure, other land uses in the area. It was based on a number of reasons to rezone it from rural to residential.
Yes, but the purpose of this process was to effectively identify that this site, amongst others, would be suitable for residential development.
Yes.
And do you accept that just because an area is identified as suitable for a particular activity, that doesn't necessarily mean that that site would not be subject to specific constraints?
I know before it's selected for a residential land use, it goes through quite a vigorous assessment of the Section 32 of the OMA, which considers a number of factors, again, infrastructure, cultural, ecology, economic.
Sorry, keep going, sorry.
Yes, which would in turn be informed by a structured planning exercise.
So in that regard, Mr. Lester, can I ask you to refer to page 355 of the bundle? It is tab 12. It's the section 32A evaluation report for PC 17.
Where would you like us to go there?
Sorry?
I'm just wondering where you would like to take us to in that document.
What I'm liking to take you to is at page 355, there are two, this is the analysis options. There are two columns, so to speak. The second option is evaluating that option, option 2, which is to rezone the land. And there is the fourth paragraph, I suppose, or the third paragraph on page 355 talks about cultural effects.
Yeah.
Yep. Sorry. So the wording on that document says, and bearing in mind, this is the evaluation document. This document states, the development of the growth areas may adversely affect cultural, archaeological and heritage sites. The loss of such sites may give rise to adverse cultural effects. These effects will be considered further as part of the subdivision and development process through the existing provisions and taking into account the vision and strategy for the Waikato River and its tributaries. Do you accept that that's what it says?
In the Section 32 report, yes.
Yes. So do you accept then that when the site was evaluated as being appropriate for residential, it was contemplated through that process or through that evaluation that the sites, including the site, may be one which could be considered a cultural, archaeological or heritage site?
That was flagged in the preliminary evaluation. I assume it would have been subject to submissions and further submissions and decisions as well. So,
yeah. But in relation to this, do you accept that it was contemplated throughout the PC17 process that there would be sites which were the subject of rezoning, which may have been considered cultural, archaeological or heritage sites?
Yes.
And so in accordance with this evaluation process, it was established that those effects would be appropriately considered as part of a subdivision and development process.
Again, yes, the preliminary evaluation for the plan change indicated that could be the case, but as you know, the significance and we'll do that defined through the evolution of plan change 17.
But plan change 17 itself identified that there would be sites that could be of cultural significance, and it would be appropriate for those sites to have any constraints in relation to cultural effects identified and worked through as part of the subdivision and development process.
At a very high level, yes.
So I guess, Mr. Lester, is it fair then to say that although the site was identified through the rezoning process as being appropriate for residential subdivision or residential development, the individual constraints of the site, in particular those relating to cultural effects, would be best left to be assessed during the consent process?
Again, it's taking a high-level statement, which, yes, it could be refined at a subdivision consent level. But again, I'd like to note that there was past sites were also contained within the plan change 17 area with a lot more notable significance. So again, the Section 32 analysis or evaluation was high level. I do agree with you that at subdivision consent stage we can refine the cultural significance better.
So then, Mr. Lester, your statements, you make several statements in your evidence relating to the assessment carried out by Ms. Cohen, where you state that the assessment is a challenge or a criticism of PC 17 because those assessments would have been carried out as part of PC 17.
Yes.
So it's your position then that on the basis that PC 17 allowed for or identified a site as being possibly appropriate for residential development, there would be no need for any further assessment under any kind of subdivision or development consenting process?
No, I would say it was open to the public. Plan change 17 was open to the public to absorb prior to the notification of plan change 17. There was public consultation specifically to the Ngaruawahia community, the local iwi, and it's distilled throughout the plan change 17 process to a point where areas of significance specifically would have been addressed or highlighted. For the subject site they weren't, hence my comments that the site had previously been subject to a robust assessment from the high-level planning documents such as the up to the RMA, the River Vision Strategy document, the regional policy statement, etc.
But that doesn't preclude any assessment being undertaken as part of a subdivision or a development assessment, including an earthworks assessment or an application for an assessment for an earthworks application.
No, it doesn't, but it's zoned the land for residential purposes with no other planning notations identified. It's residentially zoned land, which was vetted by the community, by the iwi, by all relevant parties, and was agreed as a sensible undertaking for the rezoning. And that's the basis for the land use consent for earthworks, which is
correct. So you agree then that although the site was identified as potentially being appropriate for residential subdivision or residential development, excuse me, it would have to then undergo further assessment in accordance with the in accordance with the relevant requirements through that consenting process.
It was zoned residential.
Sorry?
It is zoned residential. It's yellow on the planning maps. It's residential and it's appropriate for residential activity. That's my understanding of the zoning maps and how it works.
Yes, but it would still, but any development would still be subject to the resource consenting application process.
Of course, yes.
Which would include assessment of any possible effects.
Yes.
So I just want to check, I'm getting confused now. Are you saying it's a permitted activity, Mr. Lester? I thought it was a restricted discretionary activity subdivision.
No, it's not permitted activity. It's a restricted discretionary activity if you meet all the performance criteria.
But consent can be refused for restricted discretionary.
Just to clarify, Your Honour, the earthworks is a discretionary activity.
Yes, no, I'm talking at the moment about subdivision because you're asking about that. So I think we're going to need the plan provisions that relate to subdivision and also to earthworks, because I'd understood one was fully discretionary, the other one was restricted discretionary.
There are permitted activity earthworks as well in the residential zone.
Yes, but not these works weren't permitted, were they?
Because of the volume.
Yeah, we're about 10 times the volume, or more than 10. So if I could just understand about subdivision, the fact that something may be zoned for subdivision doesn't mean you can undertake subdivision as of right. You have to get a consent, don't you?
Yes.
And a consent can be refused.
Yes.
Now, I don't know what the discretions were. Do they include cultural matters?
It's a matter of environmental effects identification and mitigation, but the Auckland district plan did not have the site identified as culturally significant or of interest. Neither did the notified proposed district plan.
So we're talking about the operative plan at the moment. So what were the discretions limited to?
Access provisions, cultural, historic, ecological, unity.
Yeah, so cultural was there.
It's unlimited. It was subdivision. I'm sorry. That's. I don't know exactly off the top of my head what the restricted discretionary criteria are.
Yes. Okay. Well, I'll have a look, and we'll have to have a look. But you would. I just want to be clear that you understand that I'm not in the wrong place. That this requires a consent, and the consent can be refused if you don't provide satisfactory provisions in respective series of matters, and you're not sure if cultural is one of them.
It's not. There wasn't. It's not identified in the operative district plan as containing there's no notification or notation on the planning map.
That's not my question. It's a very clear planning question, and very straightforward. Is it one of the matters to which the council has restricted its discretion on, and it has to specifically list the matters that it's restricted its discretion to? Is it one of the listed matters? We can find out if you don't know.
I'd say it would be. I'd be surprised if it's not. So, but perhaps we can get that verified.
Your Honour, if I can assist, we've just done our own investigations. Subdivision is also discretionary under the ODP.
Oh, fully discretionary.
Correct.
Oh, right. So cultural must be one of the matters on which to. So if that's correct, I just want to be clear. If the council hasn't constrained its discretion to any issue, it can refuse consent on any ground then, and that would be the same for earthworks and subdivision, Mr. Lester?
Yes, discretionary activity for the earthworks and for the subdivision under the operative district plan.
Yeah, this is under the operative, I agree. Miss Ridling hasn't taken us to the new one at this stage. It's probably a good point to take the break, Ms. Ridling, and you can consider those answers and then continue with your cross-examination after the break.
Thank you.
The witness is under cross-examination, Mr. Gibbons, so he can't discuss the matter with anyone, and we'll see you all in 15 minutes or so. Thank you.
Thank you.
Are you there, parties? We're ready to go again. Can you please turn on your video?
Thank you. So, we were just partway through your questions.
Sorry, Your Honour, can you repeat that?
Sorry, we were just partway through your questions, so I'd invite you to continue.
Thank you. Mr. Lester, just to recap, we have it has been established, or you have been questioned by His Honour in regards to the requirement for resource consent on this site, both in regards to earthworks and subdivision, and that both of those activities have been determined as being discretionary under the operative district plan. Do you agree with that?
Not complying with earthworks discretionary, yes.
And that a resource consent is required for you for.
Yes, resource consent is required for discretionary activity, yes.
Thank you. Mr. Lester, if I can take you to page 84 of the bundle, and that's your evidence and rebuttal, which is paragraph 12. And in that paragraph, you state, Ms. Cohen's statements can be seen as a criticism of the PC17 process, which was led by council. I do not agree with her assessment and do not see it as necessary to reapply part 2 of the RMA, given that PC17 went through a robust and informed process, and this land use consent is simply giving effect to the intent of PC17 that the site can be used for residential development. You then go on to say PC17 went through a robust process and gave effect to a higher order planning, to higher order planning documents and the RMA. Yes. So in that statement, Mr. Lester, are you then saying that even though a resource consent is required, such resource consent or the assessment of such resource consent does not require reference to part 2?
No, I'm not.
Can you explain then what you are saying in that paragraph 12?
The point I was making was that the rezoning to residential of previously rurally zoned land provides a clear expectation to not only developers but neighbours as well that residential land use has been envisaged for that piece of land, that it's been vetted at a high level under the Resource Management Act and the higher order planning documentation such as the river strategy and the regional policy statement, regional plan. Affected parties such as NZTA would have commented on it, iwi would have commented on it. It's been through a high level vetting, and the earthworks, whilst a discretionary activity and requiring a land use consent, it's not unexpected for those sort of activities to happen at that location.
So although you say it's not unexpected that residential development would occur at that location, you accept that a resource consent was required?
Yes.
And as part of a resource consenting process, or in terms of an assessment under the resource consenting process, that assessment would include reference to matters under section 104.
Yes.
And 104 specifically requires that assessment to be subject to part 2.
Yes.
So on that basis, Mr. Lester, do you maintain your position as contained in paragraph 12 of your rebuttal evidence that a reassessment under part 2 was not necessary?
it would be, I guess, a level of degree of assessment.
Sorry, what was that?
I guess it varies to the level of degree of the assessment. Broadly, you apply the assessment, the application subject to this hearing, it did assess the proposal under Section 2 of the RMA.
Okay, so I'll just then take you to your evidence in chief. Apologies, paragraph 27. Which is page 6 of the bundle. And in that paragraph, you note that as a consequence of PC 17, the privately owned land for residential development, or apologies, both of these planning documents zone the privately owned land for residential development without any cultural or archaeological notations being applied.
Yes.
Okay, so in relation to the fact, let's bear in mind that this is a discretionary activity, so council can have regard to any matter it feels is relevant. The operative district plan zoned the site as being appropriate for residential development, but didn't apply any cultural notations to it.
No.
So if the district plan is silent on cultural effects, isn't it the case then that in order to properly assess a cultural effect or a potential cultural effect, you would have regard to the higher planning instruments, because that is what is required at Section 104?
Yes, that would apply across the environmental scale, so in cultural, ecological, yes.
So you would have regard to those higher planning instruments.
Yes.
So in effect, you go up the chain to look at the higher level planning instruments, and then ultimately you can also have regard to Part 2.
Yes.
So in this case, the district plan was silent as to the cultural effects. It had no cultural notation. There was nothing that suggested that there was any provision for cultural effects. So it was therefore appropriate for Ms. Cohen to carry out her assessment of those potential effects of the proposed activity through reference to those higher level planning instruments.
Yes, yes.
And ultimately, she would also have to include Part 2 in that assessment.
Yes.
So I'll ask you the question again, Mr. Lester. Do you maintain your position as stated in paragraph 12 of your rebuttal evidence that an assessment of Part 2 was not necessary?
On reflection, yes, an assessment of Part 2 was beneficial. I maintain that Part 2 assessment also occurred through the process of Plan Change 17.
Yes, but in relation to your client's resource consent application, it was also necessary to undertake an assessment under Part 2.
Yes.
Thank you. Mr. Lester, I will not ask any further questions in relation to that. I would now like to ask you some questions around your involvement generally with the River Terraces project. And I understand that you've been involved in the River Terraces project since stage 4, which is around 2017.
Yes.
And prior to, in the prior stages of that development, is it correct that most of the applications for earthworks and subdivision were applied for at the same time, effectively being bundled as one application?
I'm going from memory. I seem to recall that the preceding stages was concurrent land use and subdivision consent application.
So it's fair to say that the separated application at stage 6 was perhaps an anomaly in what was the normal course of the consenting applications throughout the previous 5 stages.
I'd have to look back at the preceding stages 1 through 3 to confirm that an earthworks application wasn't lodged in isolation for those. I can't confirm here and now.
Okay, but it's likely, I think, excuse me for a minute. Apologies. I can't find it. I'll move on from that. So in your evidence, Mr. Lester, you talk about the pre-application meeting that was held with the council.
Yes, I do.
And you were in attendance at that meeting?
Yes, I was.
Do you recall at any time advising the council, yourself or Mr. Glover, advising the council that this application would be different to the previous 5 stages and that it would be a separate earthworks application with a subsequent subdivision application to follow?
I do not explicitly recall making that statement to anyone.
So on the basis that it is likely that the previous 5 stages were subject to a bundled applications, that being earthworks and subdivision, it's fair to assume at that meeting that council staff would have no reason to doubt that stage 6 would be any different.
I would like to speculate. I know that we required regional council consent for stage 6 due to slope. So there was, I guess, a bit of a different element there from the contour from the preceding sections.
But there was nothing to suggest that these would be any different in terms of the bundling of the application. There was nothing to suggest to council staff that this application would be separated into an earthworks consent and a subdivision consent.
I do not believe so, no.
So is it fair to say then that when you were discussing the subdivision, it would have been assumed that there would have been, that discussion would have included, or the term subdivision would have included any preparatory earthworks which will also be required?
No, not necessarily. The reason for the pre-application meeting was to discuss density requirements for the impeding proposed district plan, changing the average lot sizes from 600 square metres down to a standard 450 square metre lot size, and the effect that would have on the subdivision design. We also discussed the setbacks from a section of Great South Road and the speed of the road. So there was land use components of the subdivision consent that were discussed. I cannot explicitly recall discussing any earthwork matters with council at the pre-application meeting.
But there was never any suggestion made to council, or there was no specific reference to the fact that these two that there was going to be a separate application made for preparatory earthworks and then a subsequent application for subdivision.
No, this pre-application meeting was 10 months before the earthworks consent application was decided upon and lodged.
So you're saying the pre-application meeting occurred some 10 months before it was decided that you would lodge a separate earthworks consent? Is that what you've just said?
Yes.
So when you went into the pre-application meeting, there had not been a decision as to whether or not there would be separate applications?
No.
So it's safe to assume then that both yourselves and the council staff were working on the basis that this pre-app meeting would be in relation to a bundled application for earthworks and subdivision.
I'm not sure that I can agree with that. No, we didn't know at that time whether or not there'd be a separate land use consent for earthworks prior to the subdivision consent. There were some technical issues we were dealing with the subdivision consent, which prevented us from bundling together. Infrastructure related, traffic related, regional council related.
But there was nothing. So you, at that point, you or your client had not determined that they were going to be separate applications.
No, I don't think so. No.
Okay. So you acknowledge in your evidence at paragraph 28 of your rebuttal evidence that you talk about council's reliance on the information in the application and the material degree of influence, the applicant's unintended omission from the application's associated Form 9.
Sorry, what was the question there?
You state at paragraph 28, when you're talking about council's reliance on the information in the application, you state that there is a reliance on information in the application as well as on the material degree of influence, the applicant's unintended omission on the application's associated Form 9.
Yes, that's what I say there. Yes.
So you're acknowledging that there was an omission on the Form 9?
No, I've said throughout my evidence that the pre-application meeting was for subdivision purposes, and that at the pre-application meeting we did not discuss earthworks. Earthworks over the following 10 months from the pre-application meeting were advanced before the finalised subdivision design for other reasons.
Then why did you refer to it as an omission in your evidence?
Again, the benefit of hindsight is 2020, and attaching the pre-application meeting notes to the application, it would have saved a lot of headache, a lot of drama for everyone. So in that regard, I've referred to it as an omission, not an intentional omission, but it was a considered decision that I undertook at the time of lodging the land use consent for earthworks, not to attach the subdivision consent pre-application meeting notes.
So you made a conscious decision to tick no on the boxes that talked about whether you had had any other conversations with staff at council, and to tick no as to whether or not you had any other pre-application meetings in relation to this application.
Yes.
Despite the fact that there had been a pre-application meeting in relation to the subdivision generally, because it had not been decided at that point that the subdivision and the earthworks consent would be split up.
Correct.
Thank you. Mr. Lester, I'd like now to discuss the application itself. And you claim, and I go back to paragraph 28 in your evidence and rebuttal, you claim that there was an overstatement of Council's reliance on the information in the application?
Yes.
Do you accept, Mr. Lester, that there is a requirement within the RMA at section 88 that the applicant is to prepare an AEE in accordance with Schedule 4?
Yes, I've had quite a few applications returned to me for not being have enough information under section 88 of the RMA.
So you accept that Schedule 4 sets out the requirements of the contents of an AEE?
Yes, I do.
And part of those requirements found at subclause F are identifications of the persons affected by the activity, any consultation undertaken, and any response to the views of any person consulted.
Yes.
Would you agree then that if a person has been consulted, they have been identified by, in this case, the applicant as potentially being affected?
Yes.
And would you agree that if site visits had been undertaken and correspondence had been exchanged, that such action would be considered consultation?
Yes.
So if Perjuli had undertaken such action with Tama Inopo, independent of Tūranga Waiwai, do you consider that they had been consulted with?
I believe I didn't undertake the consultation myself. I think that's a question that Mr. Glover may have already answered.
That's not my question, Mr. Lester. My question for you is, on the basis that if Perjuli undertook the action, which you have conceded is to be considered consultation, you know, site visits, correspondence being exchanged, you concede that that is consultation. If Perjuli has undertaken consultation with Tamo Inopo, independent of Tūranga Waiwai, do you consider that Tamo Inopo therefore has been consulted with?
Yes.
So on that basis, do you accept that in accordance with the obligations as set out in the legislation, that that information should have formed part of the AEE?
Yes.
But it didn't.
Well, I think that matters in contention. The planning report did refer to any consultation. It didn't specify explicitly Ngāti Tameopo. As we've elaborated through today and in my evidence, it was open to council to ask us to expand upon the iwi consultation that was undertaken. They did not.
But Mr. Lester, the obligation is on you as the applicant to provide the information as required under Schedule 4. The obligation is not on council to undertake any further consultation. So I'll ask you the question again. On that basis, do you accept that in accordance with the obligations set out in that legislation, Tamo Inopo, or the information in relation to Tamo Inopo, should have formed part of that AEE?
I think that the reference to iwi consultation was made in the application, explicitly mentioning Tūranga Waiwai, not explicitly referencing Ngāti Tameopo. It was accepted by council under section 88 as having the information that they require and accepted. Council knew about the consultation required with Ngāti Tameopo, but did not ask for that. So yeah, I think in responding to your question, no, I didn't explicitly mention Ngāti Tameopo, but I did refer to iwi consultation that was undertaken.
Do you accept, Mr. Lester, that Perjuli consulted with Tama Inopō independently of Tūranga Waiwai?
I wasn't a party to, I wasn't directly involved with the consultation, so I can't answer that question precisely.
Well, there's evidence put forward by Mr. Glover, and this has been traversed quite significantly in Mr. Glover's cross-examination, that there was evidence, there was consultation undertaken independently of Tūranga Waiwai, that there was a consultation with Tama Inopō independently. Do you accept that that occurred?
Yes, I do.
So then when you make reference to iwi consultation and specific reference to Tūranga Waiwai, you accept that there should have also been explicit reference to Tama Inopō, since they were an entity that were being consulted with independently of Tūranga Waiwai.
I think the point of difference between the explicit reference to Tūranga Waiwai was the long association with river terraces development and the cultural impact assessment that was prepared by Tūranga Waiwai, and the letter of currency of the cultural impact assessment that was prepared by Tūranga Waiwai. The information gleaned by myself from the preceding stage 5 section of the subdivision, where Tūranga Waiwai and Ngāti Tamiaopo's marae based whangamaro were in agreement with the mitigation that was proposed as setting a basis for the consultation that had occurred for stage 6. Again, I didn't specify Ngāti Tamiaopo because I wasn't undertaking that consultation directly, but I was aware that the consultation had been undertaken.
So you were aware that consultation had been undertaken directly with Tama Inopō?
I was aware that it was ongoing.
But that consultation had occurred prior to the lodging of the application?
Yes, what I was not aware of was the entity's independent nature. I believe that there was a collaborative understanding between Tūranga Waiwai and Ngāti Tamiaopo based on the preceding stage 5 of the development.
But Mr. Lester, you've just conceded that there was consultation undertaken with Tama Inopō independently of Tūranga Waiwai.
I was aware that that Perjuli had been discussing the application with Ngāti Tamiaopo, yes.
Correct. And the obligations under Schedule 4, the requirements are that the AEE include information about any consultation undertaken. Not the outcome of, not consultation that has had an outcome, but any consultation undertaken.
Yes.
Do you then accept, Mr. Lester, that the AEE should have made reference to consultation undertaken with Tama Inopō?
For assessment purposes, yes. I believe that had the council requested that, we would have supplied it if it was explicitly required under a Section 88 acceptance or a Section 92 further information request. That could have been provided. The level of detail regarding the ongoing consultation with Ngāti Tamiaopo, I was not aware of the nature of that, just that it was ongoing and the degree of separation between the stances of Ngāti Tamiaopo and Tūranga Waiwai.
But you accept that consultation had occurred with Tama Inopō?
Yes.
And that consultation had occurred independently of Tūranga Waiwai?
That would be an assumption that I would make, yes.
And that the requirements of Schedule 4 at subclause F is that you are to include in the AEE any consultation undertaken. That is, you agree that that is the requirement under the legislation?
Yes.
And you did not comply with that obligation because you did not specify or you did not include in your AEE the fact that consultation with Tama Inoko had been undertaken.
We didn't explicitly mention Tama Inoko, but I did mention that consultation had been undertaken. It was over to council if they want us to provide further information or details, and that we would have provided that. But my understanding is that if the legislation specifies that explicit naming of entities under consultations is required, then that would have been provided. It wasn't, but yet it was still accepted by council.
Mr. Lester, are you suggesting then that the legislation doesn't specify that you have to have or that you have to provide the names of the people you have identified or you have consulted with? You can simply make a blanket suggestion and say, we have consulted with, for example, 4 members of the community.
I think it's open to the various application to determine what level of consultation, naming individuals. Obviously, some work that I've been involved with is required quite a detailed consultation assessment and analysis. In this particular instance, I was not directly involved with the consultation, so I provided the blanket statement that any consultation had been undertaken, which it had, and that was the basis of the application for adverse consent that was accepted by council under Section 88.
So you don't accept that Schedule F is very clear in that it says identification of any persons affected by the activity, any consultation undertaken, and any response to the views of any person consulted. Bearing in mind, Mr. Lester, you have just agreed with me that when you are undertaking consultation, you are effectively identifying a person as being affected.
I was not undertaking the consultation myself.
That's not the question, Mr. Lester. The question is, do you agree that Schedule F or Schedule 4 subclause F is very clear that a person who has been identified as being affected, any consultation undertaken, and any response to the views of any person consulted must be included in the AEE?
That level of requirement, no, I was not aware of. I was aware of a requirement to disclose that if consultation was undertaken, and I disclosed that consultation had been undertaken. I didn't take it to that same degree of precision that you're referring to under the RMA. And had it been the appropriate, then it may not have been accepted by council in the first instance.
So, Mr. Lester, you are the person who prepared the AEE.
Yes.
And you say that you were not personally involved in the consultation, but I assume you received your instructions from Mr. Glover?
We collaborated, yes.
And did Mr. Glover advise you that he had been consulting with Tūranga Waiwai and Tama Inoko?
I believe there's some email correspondence there. I was sent in relation to consultation with Tamiapo and Tūranga Waiwai.
So you were aware that there was consultation undertaken with Tama Inoko, and you made the decision to not include them in your AEE despite your obligations to do so under the legislation.
That's what's happened. I maintain the line that I indicated in the application that iwi consultation had been undertaken. I did not explicitly identify in the application Ngāti Tamiapo.
And yet you explicitly identified that consultation had been undertaken with Tūranga Waiwai.
Yes, as I explained before, we had a cultural impact assessment and a long association with Tūranga Waiwai through the preceding stages of the river terraces development.
So you had a settled position with Tūranga Waiwai. They had given their approval as such, and you therefore referred to them in your AEE.
I attached the correspondence to Tūranga Waiwai, and I referred to my name in the AEE, yes.
And you hadn't received approval per se from Tama Inopo, and so you neglected to, or you omitted to include them in the AEE despite those requirements under the legislation.
I neglected to name them, simply because, as was indicated previously by Mr. Govan, the name of the entity was uncertain. We had been discussing, I was aware of consultation that Perjuli had undertaken with Whangamaro Marae, and there was a subsequent, I guess, a rebranding of the entity that we were dealing with. So it was a grey area at that time of watching the land use consent.
There was a grey area as to who you had consulted with, or whether you had consulted with two separate parties and only referred to one.
Yeah, this is not being directly involved with the consultation myself. It was the information that I was being provided from the applicant.
But you were advised that consultation was being undertaken by Tama Inopo?
Yes.
I'll move on from that line of questioning. Mr. Lester, you at paragraph 44 of your evidence in chief, which is at page 10 in the bundle, you make the statement, the consent condition review process that has brought about this appeal has meant additional participation by interested parties.
Correct, yes.
Those interested parties, I'm assuming, are Ngāti Tama Inopo and Tūranga Waiwai.
Yes, in the predicasts.
And the predicasts. But isn't it the case, Mr. Lester, that Tūranga Waiwai and Ngāti Tama Inopo were interested parties, or were considered interested parties by your clients way back in 2017 when they first started consultation with them?
I can see that, yes.
So it wasn't this consent condition review process that has meant additional participation by interested parties, because all of those parties had already been participating in this process.
Yes.
Thank you. I'm now going to move on from the questioning in relation to interested parties and the parties generally, and I'd like to talk about your evidence in chief at paragraphs 45 to 47, Mr. Lester, where you talk about these paragraphs relate to, in your words, the positive effect of protecting one borrow pit on the site.
Yes.
Mr. Lester, do you appreciate that there is a difference between an archaeological effect and a cultural effect?
I appreciate that there's a difference, yes.
And that just because something has little value archaeologically, that does not have a direct correlation to its value culturally?
Yes.
So you state in paragraph 47 that the protection of one borrow pit on the site must be considered in the context of other borrow pits within the vicinity of the site, and that it is clear from a drive to the site that there are many other borrow pits in the vicinity of the site.
Yes.
Are you suggesting then that the existence of other borrow pits in the vicinity, which are not necessarily on this site, mean that these borrow pits would be less significant culturally?
Sorry, could you repeat that question?
Are you suggesting, in your statement at paragraph 47, you say that the protection of one borrow pit within the site must, in my opinion, be considered in the context of the many other, and you say protected borrow pits in the vicinity of the site. The site is adjacent to developed area, but it is clear from a drive to the site and from the archaeological assessment referred to above that there are many other borrow pits in the vicinity of the site. So are you suggesting there that because there are many other borrow pits in the vicinity of the site, that these borrow pits on the site are less significant?
I don't think that's what I'm saying. That the I guess the distinction between the remnants of borrow pits on the application site to those in the wider area are the same as far as what they were used for. I guess the spatially separated differences, but it lies within private land as opposed to other borrow pits in the area which are located on council reserve land or around the golf course, which are more accessible to members of the public and by Ngāti Tamiapo or local iwi generally. And so preserving one of the borrow pits on the site as a I guess a compromise, I guess you could call it, would be appropriate mitigation step, one of the many mitigation steps that were proposed.
So you're suggesting then, Mr. Lester, that protecting one borrow pit is sufficient because there are other unrelated borrow pits on other sites within driving distance of the site?
Yes.
Despite the fact that those other sites may not have the proximity to Pukeahua Pa and may not hold any cultural value to Ngāti Tamainapa.
I've actually walked around that area next to the reserve that council's recently put there. I've walked to the edge of the paddock, which is on the same side of the road and the rail corridor and the cemetery as the park, and you can quite clearly see the depressions in the ground. Aerial observations of between the road and the corridor, there's still borrow pit remnants there as well. They're a lot closer to the site than the borrow pits are closer to the PAR site physically, spatially, than some of the borrow pits, which are residual borrow pits, which are on the development site.
That doesn't negate the cultural significance of this site, though. Surely that's not what you're suggesting, Mr. Lester.
I'm no expert in cultural significance, so I'd rather leave that evidence up to others.
But you're suggesting in your evidence that the protection of one borrow pit would be sufficient mitigation to cultural effects.
Oh, no. My evidence states that the signage associated with the site, as per the previous stages, there was plantings, there was plaques, there was a number of cultural mitigation factors as far as cultural mitigation from what I can determine them to be based on discussions with Perjuli and Tamiapo, which are acceptable. So it wasn't just the preservation of a pit, it was the notification or acknowledgement of Tamiapo as an interested party in the consent conditions relating to the accidental discovery protocol. So it wasn't purely just the preservation of a pit. You can't look at these things in isolation. There's a number of variables that you need to consider for cultural mitigation.
Do you accept, Mr. Lester, that the protection of one borrow pit is the preservation of an archaeological feature and does not necessarily address any cultural issues? Let me rephrase that question. Mr. Lester, given we are talking about 7 borrow pits on this site, do you accept that the protection of one of the 7 borrow pits would be the preservation of what is effectively, in your words, an archaeological feature, and that the protection of one borrow pit may not necessarily address any cultural issues that arise?
Again, the cultural significance of the borrow pits, whether you look at them individually or as part of a cultural landscape, I'm inclined to comment in my comfort area, which is based on the archaeological.
But we're not talking about the archaeological, Mr. Lester, we're talking about cultural. You've acknowledged that there is a difference between archaeological and cultural. And what I'm asking you is, do you acknowledge that the preservation of one borrow pit is the preservation of an archaeological feature and does not necessarily address the cultural issues?
Yeah, I'm sorry, I'm not sure how to answer that, but the signage, the public access that will provide to this feature will enable the narrative to be passed on, the educational aspects. Speaking from a cultural perspective, I need to be guided by the experts in this field. I'm uncomfortable making that determination here and now.
So you're saying you're not comfortable making a determination as to whether the protection of one borrow pit would suffice for cultural mitigation, but you're happy to state that the positioning of signage, education and things like that would be sufficient to provide cultural mitigation.
I'm not ignorant of all cultural matters. I went to high school in Rotorua, I stayed on the Rye. I am familiar with cultural aspects. I'm not an expert in it though. I do know through this particular job and discussing with
but you offer up in your evidence your opinion as to the positive effects of the protection of one of the borrow pits. And you talk about it would be cultural preservation. You say, in addition to cultural preservation, there will be cultural recognition through the establishment of signage. That's at paragraph 46. So you're offering your opinion in terms of what you think is positive effects in terms of the protection of one borrow pit.
And this was, I guess, supported by Turini Waiwai as well. It wasn't really my thoughts. It was informed by the feedback from Turini Waiwai Board of Trustees.
But Tūranga Waiwai have acknowledged that they don't, that the site doesn't have significant cultural value to them. It's Tamo Inopo that says the site has significant cultural value. So how can you then say that you're guided by Tūranga Waiwai in matters that of what would be sufficient cultural mitigation?
Because Turini Waiwai would know more about cultural significance than I would, and I haven't engaged directly with Tamioko regarding the specific nature of individual borrow pits versus the broader collective landscape of borrow pits, not just within the site but the wider area, whether it's a cultural landscape or a cultural feature. The language chops and changes between an independent archaeological feature or a physical feature, or how the physical feature plays out in a more a wider cultural landscape.
So you're suggesting, Mr. Lester, that Tūranga Waiwai have more knowledge of the narrative that is being put forward by Tamo Inopo, despite that it being Tamo Inopo's narrative?
No, I didn't say that, no.
You did, Mr. Lester. You said that you were guided by Tūranga Waiwai because they had more knowledge. It's not Tūranga Waiwai's narrative, is it, Mr. Lester?
I think that clarification would need to be made by Tūranga Waiwai, not myself.
No, Mr. Lester, you've just said that Tūranga Waiwai have more knowledge. The evidence that's before the court now is very clear that Tamo Enopo has its own narrative in relation to the cultural significance of the site. Are you suggesting then that Tūranga Waiwai, who do not attribute any cultural or very little cultural significance to the site, have more knowledge of Tamo Enopo's narrative than Tamo Enopo themselves?
I'm uncomfortable responding to that. I don't believe that's what I'm saying. I don't want to have my opinion misconstrued at all. The benefit of the preservation of the borrow pit, as per the previous stages, were for educational purposes to advise the general public of the occupation of the area 300 years ago. I had some comments from Ngāti Taumiopa that they were in favour of the signage indicating the presence of the borrow pits in the area. And again, that was gleaned from the stage 5 application. As it relates,
it's in relation to the stage 5 application. It's not in relation to the application that's before the court.
There's no borrow pit offered to be preserved in stage 5. So,
but we're not talking about stage 5 right now. We're talking about stage 6.
Yes, correct.
Correct. I will leave that line of questioning, Your Honour. I'd like now to turn to Mr. Lester's evidence in rebuttal. Paragraph 31, which is page 88 of the bundle. Mr. Lester, at paragraph 31, you state that Ms. Cohen's evidence regarding the archaeological features on site are incorrect. And you say, first, the Hangi pit described as S14/110 is not present on the site. Do you agree with that statement, Mr. Lester?
The statement, yes, I agree.
Mr. Lester, can you turn to page 545 of the bundle? Your Honour, that is tab 20. Mr. Lester, that document is the authority issued by Heritage New Zealand in relation to the archaeological features on the site?
Yes.
And do you agree with my reading of that document that clearly states at the top, tēnā koe Brent, and then it goes into what we can only call the subject line, and it makes reference to application for archaeological authority under Heritage New Zealand, Pouhere Taonga Act 2014, authority number 2020/519, S14/110 and S14/373, Hangi Pit and Borrow Pits, 5851 Great South Road.
Yes, that's what it says, yes.
Do you still maintain your position then, Mr. Lester, that there is no Hangi Pit on the site?
Can I just, before we get into that, could I just clarify, just to see that there is, that there's some dispute internally. If you go back to 514, which is tab 16, which is the archaeological assessment, 3.5514 shows the two particular sites within a particular site and describes the one as a hangi pit and the other one, if you have a look, showing the borrow pit and umu. It says umu rather than hangi pits, but same thing, I think. S14/110, just to make sure there's no argument about it. Have you found it, Mr. Lester?
Yes, I have.
So, is your evidence correct, or is this evidence correct? Which is correct?
It's a, the honey pit was observed, was uncovered by the landowner, Mr. Prendergast, constructing a track down from his curvature around his house down to the lower terrace, and he accidentally destroyed that site. Is my recollection from the archaeological report. The site S14373 relates to a cluster of borrow pits, some of which are within the site, but also...
Let's focus on the one Ms. Ridling's asking you about. You say first the hangi pit described on S14110 is not present on the site. So what are you meaning, that it's been destroyed?
It's been destroyed, it's on the periphery of the site.
Okay, then why would you apply for consent to destroy it?
Because we applied for the authority to destroy it because it was still registered. It's not physically on the site.
So when you said it wasn't present on the site, you don't mean that it doesn't exist on that site or didn't exist in the past on that site. What you're meaning is it's already been destroyed.
Correct. I think there was also a, I'm not sure if it was...
Well, before we move on, if that's your answer to the question, because I understood you to be suggesting that Ms. Cowan had got it wrong because she referred to it. Let's just see if that's the issue. So my understanding is you accept it was on the site and is identified on the site and you have an authority to destroy it. Your position is that it was already destroyed and you didn't need an authority to destroy it.
No, the reference in Mrs. Cowan's evidence related to a archaeological registered site that did not exist on our site. I think it might have been a typo or something.
Well, let's come to that in due course. Ms. Ridling was asking about the hangi pit or the umu. You're saying, yes, it is on that site, and yes, we've got an authority to destroy it, but it was already destroyed. Is that your position? Just want to be clear what you're saying.
Yes.
Because you seem to be suggesting it's not present on the site, but it was present on the site. It's just been destroyed.
Yes, yes, it was. I was just, in this particular instance, the question from Ms. Ridling related to my statement that the evidence by Ms. Cowan erroneously referred to an archaeologically registered site which did not actually exist on the site.
I don't know. Her question was about paragraph 31, the sentence which reads, first, the hangi pit described as S141110 is not present on the site. Now, we've clarified that it is actually present on the site and you have an authority to destroy it, but it was already destroyed. Is that correct?
Yes, it's correct.
So we should change that to read the hangi pit described as S141110 is no longer on the site because it was destroyed by Mr. Prendergast. Is that what you're actually saying to us?
Yes, they would.
Okay, right. So I'll find out if Ms. Ridling has any more questions about that before we move on, because I was confused, and when I saw this report, it appears clear that it is on the site, or was at least on the site, and has been destroyed. So do you accept that explanation, Ms. Ridling? Or
I do, Your Honour. I have no further questions in relation to the hangi pit.
Right, that's fine. So that's fine. So,
Your Honour, I'm just mindful of the time.
Well, it is what it is, and I'm hoping that you can complete your questions before the end of play today, that's all. Honestly, Mr. Ketu and Ms...
I'm not sure that that's going to occur.
Well, let's just carry on. You seem to be taking a lot longer than you estimated.
Yes, I am, and I do apologise for that, Your Honour.
Well, parties need to keep in mind their estimates, because if they run on too long with them, we've spent a lot of time with respect preparing the question rather than asking the question.
Yes, I will.
I know you haven't appeared in front of me before. I'm one that prefers to go for the jugular and deal with the question, get it out in the open and move on to the next matter.
I would bear that in mind, Your Honour.
That's why I interfered on this occasion, because we're well over the hour now. So
I would
carry
bear
on.
that in mind, Your Honour. Apologies. Mr Lester, in light of His Honour's comments, can we now go to paragraph 32, where you talk about the review submission, or the proposed Waikato District Plan review submission, which was lodged by...
Evidence.
Oh, sorry?
Section paragraph 32 of my rebuttal evidence, my evidence in chief.
Your rebuttal evidence.
We're just dealing with 31, we're now on to 32. And it refers to the LIDAR image showing borrow pits.
Apologies. Mr Lester, you talk about Perjuli having included a helpful visual aid showing scope and coverage of the borrow pits within and surrounding the site, and you then say this image is reproduced below. You then talk about, obviously, the image is the LIDAR image of the borrow pits. At paragraph 33, you then say the diagram above is an excerpt of an image contained within the technical material for the section 42A report relating to the proposed Waikato District Plan. Mr Lester, is that diagram from, is it the helpful visual aid submitted by Perjuli, or is it the excerpt of an image contained within the technical report?
It's the source. It's taken from the technical report for plan for the section 42A report.
Okay. Thank you. And you've acknowledged in your evidence that this is an excerpt of the diagram, therefore it is not the diagram in its entirety.
Yes.
Your Honour, I'd like here to seek to have the introduction of the exhibit that I have put forward to, if Ms King can share her screen.
Has the witness got a copy?
No, I've only just emailed it through to Ms King as per the directions.
Well, let's have a look at it.
They were sent to the other party.
You've got to find out if the witness knows about it, otherwise you'll have to produce it through another witness. But you can put questions about it to him.
Which one are we talking about? You sent to...
The witness should know about it, Your Honour. It was referred to in his evidence as the excerpt of the image. I'm assuming that he...
Well, that's what we need to find out, if he knows that that's not the one, is it? Or is that the one?
No, that's not it.
Right, the other one, the one with the picture of land with dots on it.
Yes, that's it.
Yeah, well, I haven't seen it either, but I'm hoping that'll help the hearing manager find it.
It's on the other tab.
Yeah, she's trying to bring it up now.
She was sharing the screen.
Yeah, that looks like it.
Mr Lester, do you recognise this document at all?
I've seen that image before, yes.
And you accept that this is the full image of the excerpt that is contained in your rebuttal evidence?
Yeah, just down the bottom right-hand corner, yes, seems to me, yes.
Thank you.
Just so I can understand it, it took me some time. Where it's red, the land is red, that means that the borrow pits that are shown there of yellow have been destroyed. Is that correct?
Correct.
Is that right, Mr Lester?
Yes, that was indicated in the source document, yes.
So for example, those in Crowell Crescent, just to the north, there's only a couple there, but they've been destroyed?
Yes.
And so those that still exist appear to be those that are in the cemetery and the land adjacent, and also there seems to be a fork a little to the north. I can't identify it exactly, but there's 3 or 4 pits there. Obviously there's some on the other side of the Waikato to the north, but most of those still existing are either in the cemetery or the land adjacent to it. And so those that still exist appear to be those that are in the cemetery and the land adjacent, and also there seems to be a fork a little to the north. Obviously there's some on the other side of the Waikato to the north, but most of those still existing are either in the cemetery or the land adjacent to it. and I think it goes on into the golf course further to the south as well. And there's a number identified on this site. Is that right?
Yes, there's seven of them shown on the subject site. Yes.
I think 8, but it doesn't really matter. I'm not going to get into the maths at the moment. And the blue area that is to the south of the subject site, those haven't been destroyed. That's just another colour to distinguish it from the subject site. Is that right?
We'll have to scroll down so we can see the key, if that's all possible.
Well, it says it's residential development 2018-19, so I don't know if it's been developed or not.
I'm about to approach that, Your Honour.
Okay, that's fine. So all I can say is I don't understand all of the underlying colours, the yellows, the blues. The grey seems to be the subject site, and there's another one on the northern side of Waikato that appears to be differently. So those may be residential developments, of which this is one. Would you like to go through that then, Ms. Ridling?
Sorry, there's just a concern, sir, that the whole of the diagram can't be seen on the share screen.
Yes, I must say it seems to only include part of it, and I'm not sure.
Oh, there you go.
Yeah, now it's very difficult to get that all in.
So the bottom one, that bottom one isn't relevant.
No, so let's take the bottom one out. Can you move up
so
further?
Let's take. I think if you scroll back up.
Up, not down. We don't need that bottom one. Well, we have to try and get all of that into one screen. I do have a printout of it showing most of it. Can you go up a tiny bit further?
I think it's probably more relevant to have it so that we can see the legend.
Yes, so let's just take that down. We can scroll up if necessary. So that, according to us, is what we have in the printed copy, Mr. Lester. That shows the full legend, and it shows the aerial is 1941. And I think it says schematic showing Ngaruawahia Borough Pit attrition 1948 to 2020. And I think the colour codes is to give us a key into what that's about by virtue of the yellow, red, blue and clear, which appears to be residential development 2020 affected by this current matter, and there's some to the north of the Waikato River also.
Yes.
So as I take it, looking at this, there's only about 5 or 6 borough pits that aren't affected by some level of development. That's off State Highway 1. If you look north, just as you come up to the Waikato River, there's one at the top there. Oh, you can't quite see it. Can we go up, scroll up a tiny bit? Just scroll up a tiny bit on the whole thing, to the top. Go to the top. No, the other way, not bed down, up. Well, we'll stop there. You see there's the one near the Waikato River. There's some on the northern side, but they appear to be that grey colour. The one on the southern side of the Waikato River appears to be unaffected. And then there's another 4 in the V between 2 roads, the State Highway obviously, and a road that crosses the main trunk line. Do you see those, Mr. Lester?
Yes, I do.
Now, those appear to be ones that are unaffected by any development proposed. The others appear to have been affected at various stages by land use, or affected. I don't know what the difference between affected and attrition means, so that's the subject we might. So can you scroll down again, Madam Registrar, to get us back to the subject site? No, not right down at the bottom, just up a bit more. That's it. Thank you. So, Ms. Ridling, carry on with your questions, which I assume might have something to do with these colours.
You have covered a significant amount of my questions, Your Honour. Mr. Lester, you then talk about, at paragraph 34, you say the image that is in front of us, shows that the site is far from unique in having borrow pits present, noting again that the pits on the site are modified and damaged borrow pits. Rather, borrow pits are a regular feature of the landscape, and if an expansive view was taken, it may be that most of Ngaruawahia could be found to have evidence of borrow pits. That highlights that the particular site should not be singled out as somewhat unique.
Correct, yes.
Do you accept then, Mr. Lester, that When we look at the yellow overlay in accordance with this picture, that those borrow pits have all been affected by intensive land use.
Yes, it's kind of interesting. It should be highlighted yellow on subject site as well.
No. The overlay, which says that they have been affected by intensive land use.
Yes.
And then there's a red overlay that suggests that those borrow pits have been destroyed.
Yes, I see that.
And there's a blue overlay which indicates residential development. That's, I'm assuming, stage 5 of the river terraces.
Yes.
And then we have the grey area, which is the subject site, which, according to this image, is as yet unaffected.
Yes.
Okay. Mr. Lester, can I then take you to page 207 of the bundle?
Well, given that he's accepted it, we give it an exhibit number. I can't remember what we're up to at the moment. We've got
This is our first. Perhaps if we make it B3.
So A would be, no, we just give them exhibit numbers. So exhibit A would be the contour map you've provided. Exhibit B is the schematic map showing Ngarawahia Borrow Pit attrition full map. So those are the two exhibits so far.
Thank you, Your Honour.
Does anyone object? Exhibit A is the contour of the site. Exhibit B is a full attrition map of Borrow Pit map. Thank you. Carry on, Ms. Ridling.
207, that's at tab 11, Your Honour.
You want to move to tab 11?
Yes.
Thank you. What page are you looking at in tab 11?
207.
Thank you. Sorry, I'm a bit slow. We have to find the document and then find the various...
No, that's fine, Your Honour.
So that's the historic aerial photography, so there's nothing on 207, so I presume it's the pages that follow.
So I was looking at the pages to follow, and we have pages 208, 209, 210, 211, 212, 213.
Are you asking a general question of the witness, or do you want to take him to one of those in particular?
I was going to ask it, well, I was going to take him to all of them, but mindful of the time, I won't. I'll ask a general question. Mr. Lester, you're aware of these aerial photographs?
Yes, I am.
And do you acknowledge that when you look at page 208, which is the first aerial photograph of the site taken in 1941, it's very clear that there is very little development surrounding the site, save for the cemetery and the road, and the depressions, which can be identified as the borrow pits, are very clear on that site.
I can also see the rail corridor.
Correct. No, on the site.
On the site, yes.
And so the first photograph, it's clear that there are a number of borrow pits around. Clear that there's a number of borrow pits in the vicinity of the site.
And I think he's making the point that you can also see a couple of borrow pits in the cemetery and some south of
absolutely
the line as well. But
yep.
Yes.
Mr. Lester, I'd then like to take you to page 213, which is the final aerial photograph, and that is taken in 2017.
Yes.
Do you accept, Mr. Lester, that there's a stark difference between the initial photograph taken in 1941 and the final photograph taken in 2017? Notably, that most of the area surrounding the site has been significantly affected by development, and that there are very few borrow pits that are discernible in that photo.
Well, yeah, it's This particular image that I'm looking on at 213, this is different nature. The contrast is a lot different than the initial 1942 aerial photograph. But yes, I see there's a lot more development which has occurred. Yes.
So the areas that are adjacent to the site, I think to the south of it was blue in the previous schematic map. Those clearly have all now been destroyed.
Yes.
And that to the north of the site, those have been destroyed as well.
And yeah, with the red overlay, yes.
Yeah. So, noting your responses to that, Mr. Lester, do you still maintain that the borrow pits on the site are far from unique and that borrow pits are a regular feature of the landscape?
I think the borrow pits on the site are exactly the same as the multitude of borrow pits to the south of the park, which is subject to agricultural land use, cattle damage. I know that the point of difference would be that the borrow pits, as they relate to the subject site, are on a residentially zoned piece of land, whereas the borrow pits immediately to the south of the park are on council reserve or on rural land. The question, answering to your question, I base my comments from the archaeological reporting, which reaffirms that the borrow pits on the site were part of a wider cluster of up to 200 borrow pits in the immediate area.
And so on that note, you say it's been recognised that these borrow pits are were part of a cluster of up to 200? But most of those have now been destroyed.
I'd have to refer back to the archaeological report to see where this cluster of 200 borrow pits actually relate to, and then reconciliate what borrow pits are still present. There'll be a bit of an undertaking there. As I explained to you earlier, I actually walked around that site, and the borrow pits immediately to the south of the park on the western side of the cemetery, the road reserve, were observable. Obviously, not where the big water reservoir is, but further to the west, I observed some borrow pit features still in existence.
Do you accept, Mr. Lester, that most of the borrow pits, I mean, based on these photographs, which are, in a sense, a visual chronology of the development that has taken place around the site, that the borrow pits on the site are, in effect, all that is left?
No, I don't see
within the proximity of Pukeahua?
No. I don't accept that. I say that because, as I explained, I have observed myself personally borrow pits which are closer to the Pukeahua Park site than to the subject site. I've seen the borrow pits myself, so I don't understand.
Okay, and does that, in your opinion, negate the significance of the borrow pits on this site?
It doesn't negate them, no, but it doesn't make them different. It doesn't make them unique. And that was the point that I was trying to make in my evidence.
So you mean unique in terms of them being an archaeological feature?
Well, of the location specific to any other borrow pits in the immediate area. there are other borough pits in the immediate area, and proximity to the PA, which would raise the question on spatial separation from the PA to the borough pit. What was more connected to the actual PA compared to the borough pit remnants, which are on our side, which are more spatially distant than some of the other borough pits that I observed.
But not necessarily any less culturally significant.
Not less, no, just a bit further away, a bit more discreet from the actual PA through the intervening development reserve, the cemetery, the rail, the road.
I think we've gone past time and we seem to be going in micro circles now.
I wasn't going to proceed with that questioning.
So we'll move to another issue tomorrow. So the witness will just have to be held over till tomorrow morning. I want to just now try and address where this is going. We seem to have had the wheels fall off very quickly. So how much longer are you likely to be, Ms. Ridling?
Literally 5 minutes, Your Honour. Not even that.
Okay, well, if that's the case, I think I'd rather complete, because I don't like keeping witnesses under cross overnight, even though obviously they have more questions. So if you've got 5 minutes, it's starting now.
Actually, Your Honour, I'll finish my questioning there.
Thank you.
Okay,
thank you, Ms. Ridling. So I now need to address Mr. Ketu. You were not clear how many questions you would have of this witness. How long do you think you'd be of this witness?
I have no questions, sir.
Thank you. I'm fairly sure Ms. Thomas does. Your estimate now, in light of what you've heard so far?
It would still be the 30 to 40 minutes, sir.
Thank you. So, Mr. Lester, please don't discuss this with the solicitor or anyone else overnight. I'm sure it's the last thing you want to do anyway, but if you would do that, you're not under cross at the moment, but I'd prefer that you didn't discuss the matter with anyone, and I think that is a preference I rely on. I've already indicated I rely on counsel to maintain those rules and the circumstances. Then we have approximately 40 minutes of Ms. Thomas tomorrow morning. Then there could be some questions arising. I'm not going to ask you how long, Mr. Gibbons, because it's a bit hard to know yet, but I'm assuming you may have 10 or 15 minutes worth.
Yes, sir.
Then the court may have some questions. I'm not sure how long. I don't think I have many at this stage. Say another 15 or so anyway. Let's just assume that for the moment. So that takes us 40 minutes plus 30, so it's an hour and 10. And if we're starting at 10 o'clock, that probably takes us to 11, just after 11. How many pages is your opening, Miss Ridling?
Less than 20, Your Honour.
Right, well that should take us through, then we should be comfortably finished before lunch, in theory, at least. And then that takes us to your two witnesses. We've got Ms. Cowan. Is that the order you're going to call them in, or a different order?
I was going to call them in the order of Mr. Hill and then Ms. Cowan.
That's fine, thank you. Mr. Hill, and I'll start with those parties who may be closer to you than, so I'll start with Mr. Ketu. Did you have questions of Mr. Hill?
Yes, I did. Sorry, sir.
How long? How many?
Maybe 10 minutes. I don't have very many for Mr. Hill.
Thank you. Probably, I'm not sure of the order at this point, but probably you, Ms. Thomas, at that point.
For both of the council witnesses, I would have very little, 5 minutes, if any.
Right, for both. So
yes.
I'll come to the other one in a moment. And Mr. Gibbons, for you, how long?
Yes, probably 10 to 20 minutes for Mr. Hill and 30 to 40 for Ms. Cowan.
Thank you. And so, Mr. Ketu, did you have much in the way of questions of Ms. Cowan?
Yeah, it'll be about 10 minutes for her as well, sir.
Thank you very much. So, in theory, that should mean we complete both those witnesses and start the opening, Mr. Ketu, for your client. How many pages is your opening?
Oh, so was that start my openings tomorrow?
Well, yes, in theory, you know how quickly the wheels fall out on these things, but they do speed up from time to time as well. So if we get to your opening tomorrow, which there's a good chance we could, how many pages is your opening?
It's about 25, but I don't plan on going through those in their entirety. So I would need maybe 35, 40 minutes.
Well, as you probably detected from the discussion I had with the first council, it's a little bit more Socratic than that, but if it's 25, we should get through in around 2 hours or a little less.
I won't need 2 hours, sir. I'm
well,
anticipating...
it depends what my questions of you are and
yes,
how
absolutely.
difficult they are. That's what can take the time, but I don't know that there's as many issues. It all depends what the issues are, really. So that would be... I don't think we'll complete that, but we may. If we're having a really good day, we'd complete that. Then we've got your... Is it 3 witnesses?
Yes, sir.
And that's for Thursday. I'll ask about that tomorrow. I don't think there's any help in us going any further than that because things do change.
Yes, and I know the witnesses for my clients will be here on Wednesday because of the translation services as well. So
that's right. So they would start on, that's what I'm saying. If we get through your submissions, we won't be going to your witnesses. Well, that's a job for Wednesday. But I will be asking about the timing for those witnesses tomorrow, obviously.
I do. Yes, that's helpful, sir. I do have one question, and it's just to gauge whether or not it'll be helpful for the court around the presentation of evidence. I mean, my clients have prepared summaries of them, but is that helpful for the court, or...?
No, it's just another form of evidence that sometimes is different to what's already there, and it just confuses everyone. It's like reading another brief. So we understand the evidence in general terms. There's little bits you're clearly going to knock the edges off, what our misunderstandings on various things. I'm trying to signal the areas of particular interest to us as we go. One of the issues is whether or not the tikanga and the korero around the two traditions for Tai Manupo and Mai Unupo and for Ngāti Mahuta are very different. And as you've seen to date, I don't see a great distinction in terms of either the tikanga or the korero around the two groups. The issue, I think, may turn more on the issue about mana whenua rather than the oral traditions or the tikanga of the two groups. But that's an area where obviously we're interested in knowing if we've misunderstood and there are any significant differences. That's why I made the point earlier. It appeared to me, and I say this in ignorance, that both Tai Manupo and Ngāti Mahuta are not only both Tai Nui, but they are also part of the Kingitanga movement. Now, if I'm correct on that, that would make sense to me that there wouldn't be so much difference in terms of tikanga. But I don't want to discuss that now. I'm just saying that that's one of the matters we're really interested in knowing. If there is a difference in that regard, if there isn't, then the issue then comes down to the issues of ahikā, and it seems to me Ms Thomas is making it clear there's an issue from their point of view as to whether these are in fact borrow pits or rua, and that's a definitional issue which may turn on, it could turn on tikanga as well, and I'm not clear on that yet. So I'm going to be relying a lot on Commissioner Prime to point me in the right direction there. But clearly I want to hear from both of you on that. So we're wanting to understand where the points of difference culturally are between the two groups. If there isn't a lot of cultural difference between the two groups, then the question is they represent separate whānau or hapu groups, and the relationship between them is a matter, obviously, which is something we're wanting to hear about, and that's what most of your evidence seems to be about, really. Any of that cause you concern, Mr. Ketu?
No, I'm grateful for those intimations.
Is that helpful also, Ms Thomas? It wasn't as clear as it might have been whether or not you are in fact part of the same. I thought you were both part of the same canoe. And by I, about you, I'm meaning the two groups that are appearing, not council. So it would be helpful to clarify that, and where if there are points of difference. Quite simply, if I can go back, both cite the oral tradition, and they seemed all identical for practical purposes, at least to the par site at Kaihanga. Thereafter, they seem to also unite in terms of kingitanga movement, and I'm not sure whether or not what's occurred in the meantime, because some of the who was the witness? Was it your witness, that Mr. Burnsley, is it?
That's Tūranga Waiwai's
so
historical.
that history goes into a number of battles through the 1700s into the 1800s, and I must confess it was all a little difficult for me to follow. Commissioner Prime may have a better understanding, but in fact I don't think we should rely on our own understanding. We should check with both Ngāti Mahute and Ngāti Nupo to make sure we understand the differences and the commonalities.
That's very helpful, sir. Thank you.
Thank you. And again, one of the questions is, are the parties actually that far apart, or is it simply that the question of the ahi ka is the issue that separates you on this occasion in relation to this site? Again, that's an issue we're well familiar with, because I have done a lot of cases in the Bay of Plenty, and so ahi ka becomes a very critical issue, as you would understand, when there's so many iwi and hapu with cross interests. We'll take the break. We'll recommence again at 10. I have another matter on at 9, so I will not be able to start till 10 o'clock, and in any event I don't think it's helpful. We found it very wearing by the end of the day. Thank you, everyone. We'll take the adjournment. Is there any other matters outstanding that are of concern or comment from anyone? We are trying to do the best we can in a very difficult situation with these cases, so if you have any improvements, please mention them to the registrar. We're using a different system on this occasion, which seems to give us better camera angles, but we do have the difficulty of bringing everyone up from time to time. We'll take the adjournment. Thank you. Sorry. Yes, karakia. I'm going to stand, if we'd all stand, and well, I'll invite Commissioner Prime again to give karakia.
E noi tātou. E pae tō mātou matunui te rangi. E tuko tana mātou tēnei reo paketau ka moimiti ki a koe pā. Mua tini mana ki tanga i uhi mai ke hui e mātui tēnei rā. Mai te timitanga I tāta nei taino ki tēnei haora hako mutunga. O tēnei rā te whakawheta te whakamoimiti tau ingoa tapu. Te whakao ke tukuroria ke a koe pā. E te ina te ke a koe ke mranaki tēnei koe tēnei o mātou. E uehea tēnei o mātou kāinga. E uehea tēnei o mātou tūhotanga. Wai ho tonu koe te hātau waido tapu ki unga I tēnei a mātou. Ke hoke ki te hakatā. Ke pai e te hokinga mai a pōpō. Tēnei tonu te inoi ki a koe pā mau ne whakamana mai. I runga ni te mua tāutama te kai whakora koe ukuraiti. Amen.
Amen.
Kia ora tātou.